6, Annexure 6, my lord.
And never mention in this court without brief. If a senior says, just go to the Chief Justice Court and tell them accommodation, that will not happen here. You must at least have the paper book to know what the matter is about.
Sorry, my lord.
Yes.
My lord, page 36, Annexure 6. Only the representation is to be directed to be considered.
Ah. What is the...
My lord, if your lordship comes to page 36, my lord, he was seeking a regularization of service. This honorable court directed her to file a representation which shall be considered.
Considering that the single judge has permitted the petitioner to make a representation which can be considered by the opposite parties in a time-bound manner, the court sees no reason to interfere with the impugned order. In view of the fact that the order is passed nearly 3 years ago, a last opportunity is granted to the applicant to make that representation, not later than 1st May 2023. And if it is filed, if it is made by that date, it will be considered in accordance with law, and a reasoned order shall be passed thereon by the authorities, not later than 1st August 2023, and communicated to her within a week thereafter. The writ appeal is disposed of in the above directions.
Item number 2.
Just note down.
2 also similar, my lord.
2 similar.
Yes, my lord. Same order.
All right. This cost list was strong. Sunita Kumari Pradhan. See the way it's typed out. You see the cost list here. Sunita Kumari Pradhan versus Sunita.
Item number 3.
The Lordship, I pray time for Mr. A.K. Rai advocate is suffering out of a pen operation. Kindly adjourn it. This is the first it has come. Kindly adjourn it for a short, at least for 15 days, Your Lordship.
It's a notice returnable. Down his name. It's a notice returnable. 2nd August 2023. In the meanwhile, there should be a stay of the impugned judgment of the learned civil judge.
Item number 4.
Ma'am, I have challenged the order of the Honorable Single Judge. The matter relates to recruitment, as well as also I have challenged the resolution passed by the government since the OA was in the year 2018, no counter has been filed, but the Honorable Single Judge has directed by a flux of time, the writ petition has become infructuous. The OA was the original application was in the year of 2018. Page 47 is the order of the Honorable Single Judge.
Counsel for the appellant. You are for the
Yes,
state.
ma'am. I'm for the state.
He says it didn't become infructuous, sir.
My lord, Lordship, kindly see the order, my lord, impugn order.
Just 2 lines. It simply says it is stated without mentioning who stated.
Yes, madam. It is contended by efflux of time, it has become infructuous.
Who contended? Nobody says. The order, the impugn order dated 12th September 2022 reads as under paragraph. The order is silent on which counsel contended that the writ petition had become infructuous, when in fact counsel for the appellant writ petitioner states that from the point of view of the appellant writ petitioner, the case had not become infructuous. This was a writ petition that stood transferred from the Odisha Administrative Tribunal to the High Court after abolition of the OAT. You have superannuated, is it?
No, man, this is a matter related to recruitment.
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 This was a matter relating to recruitment. And the subject matter is still alive. Paragraph. In that view of the matter, the impugn order is hereby set aside. And you say full stop. The pleadings were complete in the
No, man, counter has not yet been filed.
Full stop. Further, even counter affidavit had not yet been filed in the either before the OAT or before the High Court. Paragraph. Keeping in view the above factors, the impugn order is hereby set aside. And writ petition civil bracket OAC number 129 of 2018 is restored to the file of the learned single judge in the roster bench, where it will be listed on 14th August 2023. The respondent state will file its paravis reply to the petition not later than 1st August 2023. And the appellant will file rejoinder, if any, thereto on or before 14th August 2023. No further time will be granted to either party for that purpose. The learned single judge is requested to proceed with the hearing of the writ petition on merits and endeavor to dispose it of as expeditiously as possible.
Item number 5.
May I please, my lords? Disciplinary proceeding initiated against the opposite party respondent, my lord, 2009, because the delinquency detected after the transfer from that post in 2004. Yes, there is a delay of 5 years, my lord, but he never objected to the delay. He participated in the inquiry, participated in the proceeding, punishment was passed, filed appeal. Appeal has reduced the liability to 1/3 from 50% by the disciplinary authority. Now, in spite of that, the learned single judge also my content page para 13 of the writ petition, the impugn order. Court carefully examines the memorandum of charges, order passed thereon, and the memorandum of appeal and petitioner. It is not in dispute that the shortage of the plantation had taken place due to the incumbency of the petitioner. It is recorded that he was relieved on 24/2003 and charges were framed on 2006. Next paragraph. The ground of delay as advanced by the learned counsel for the petitioner has not been meaningfully answered by the OFDC. In the reply in the answer, it is only stated that detection was made in 2004, but there is no plausible explanation as to why the authority had taken 5 years more years for the
Sir, the person is retired now.
Man, yeah, really, the petition, my lord.
It's all right.
In 2019,
It's
He
okay.
has enjoyed the stay of granted by this honorable court.
It's all right.
Now, the only question is whether the single judge is correct in
We'll
saying
confine it
that
to the-
no further
we'll
recovery.
Confine it to the facts of the case. You
Ma-
say the.
Well, may I please that this only one minute, Mirror. The observation of the single judge is main one. On the factual aspect, it can be seen that while considering the appeal, petitioner appeal authority has been considered and reduced the amount of recovery as well as the direction related to the implement has also been modified. As rightly submitted by the learned counsel to the OFDC Limited, Mr. Das, the contour of the court to exercise the jurisdiction in a department proceeding evidently when there is no procedural irregularity is limited. It is the case at hand, finding as so far as completion of the petition is concerned, is sustained by the OFDC Limited, cannot be faulted, save except a delay. A delay occurred in the initiation. There the proceeding was completed, appeal was completed. After that, what is the question of initiation delay now? They never challenged the initiation proceeding. That is my only submission.
Or the challenge by the Orissa Financial Forest Development Corporation Limited, bracket OFDC, in the present writ appeal is to a judgment dated 12th October 2022, passed by the learned single judge, disposing of writ petition CV 3513 of 2012, filed by the respondent, who incidentally is at present 64 years old. Full stop. Paragraph, the respondent had challenged the order passed by the disciplinary authority at the end of a disciplinary inquiry,
And the appellate authority. You challenge the appellate
directing recovery of a sum of rupees 108,258 and stoppage of one annual increment with cumulative effect, as well as the order of the appellate authority reducing the recovery amount to rupees 72,172 and directing stoppage of one annual increment without cumulative effect. Stop. Paragraph. The factors that weighed with the learned single judge in further modifying the above punishment by confining the recovery amount to rupees 22,000 were as follows. One, the disciplinary inquiry had been initiated 6 years after the alleged misconduct.
Discovery 5 years. 5 years from discovery of it.
6 years had been initiated on 19th May 2009. Nearly 6 years after the respondent had been relieved from the post that he was holding, during which time loss is supposed to have been occurred to the OFDC. 2, there was no plausible explanation for the delay in initiation of the disciplinary proceedings, when admittedly the loss was detected sometime in 2004 itself. 3, the respondent retired in 2019, whereas the so-called dereliction in duty occurred in 2003. That is more than a decade and a half before the respondent retired. Paragraph. Having heard Mr. Patnaik, senior counsel, appearing for the appellant, and having considered the impugned order of the learned single judge, the court is of the view that no sufficient grounds have been made out for interference. Full stop. It is nevertheless clarified that the impugned order of the learned single judge will be treated as having passed in the peculiar facts of the case and will not constitute a precedent. The writ appeal is dismissed with the above suspicions.
Item number 6.
May I please, Your Lordship? Well, here the appellant has challenged the order of the learned single judge, but the learned single judge has allowed the writ petition filed by the respondent number 4 by quashing the order of the director and also by directing the authority to hand over the charge of the principal in charge to the respondent number 4, my lord. My lord, here, this is not a question of inter-se seniority, my lord. Admittedly, my lord, respondent number 4 is senior to the appellant. Here, my lord, due to some serious allegation that the respondent number 4 was selling fake certificate and also was involved in some financial irregularities, my lord, he was divested from the post of principal in charge. My lord, under Annex 8, the director passed the order by divesting. Thereafter, my lord, he challenged by filing a writ petition, my lord, and the writ petition was allowed. My lord, under Annex 14, my lord, kindly have a glance at page 117. Well, it starts from page 117. Lordship may kindly come to page 134, my lord. Lordship, page 134, my lord. May I submit, my lord?
Yes, yes.
Coming to the main ground urged by Mr. Das that in absence of opportunity of hearing, this court finds that the petitioner was straightaway divested of all responsibilities of the principal with immediate effect only on the basis of allegation without informing the particulars of the allegation and giving him opportunity to have his say regarding the same. True, an inquiry has been directed to be conducted, but then this is not a case of suspension pending withdrawal of disciplinary proceeding, which is permissible in law. Divesting the petitioner from the responsibility of principal in the facts and circumstances of the case amounts to a penal action and definite downgrading of his status inasmuch he was forced thereby to work under his immediate junior. My lord, here, my lord, my answer to this is, my lord, principal is charge is not a substantive post, my lord. The substantive post of respondent number 1 and respondent number 4 and the appellant is, my lord, lecturer. Here, my lord, it is just an additional responsibility, my lord. Here, by no way he has been downgraded, my lord, because of some financial irregularities.
Once you say what the reason for reverting him as lecturer is this,
Yes,
that
my
is
lord.
financial irregularity.
Financial and he was selling, my lord, fake certificate.
So the more severe you mount your charges like this,
Yes, my lord.
financial irregularities, fake certificate,
Yes, my lord.
all the more necessary for you to hold an inquiry, sir.
Yes, inquiry is held, my lord.
No. Giving him an opportunity to answer. No inquiry. Inquiry is an internal inquiry, sir. You have to issue him a show cause notice.
Lordship-
He has to be given an opportunity.
Lordship, may kindly have a
to
glance
reply.
at the last part of the order for a moment.
Sure.
In the result, the writ petition by WPC number such and such success and is therefore allowed. The impugned order under Annex 9 is quashed. The opposite party number 2 is directed to place the petitioner in charge of the principal cum secretary of the college within 2 weeks from the date of communication of this order or on production of certified copy thereof by the petitioner. Further, the petitioner is directed to render full cooperation to the concerned authorities in the conduct of the inquiry in relation to the allegation leveled against him. Consequently, the writ petition is dismissed, my lord. My lord. Here, my lord.
Writ petition is dismissed.
But two writ petition.
There are two writ petitions.
Two writ petition, my lord. Well, the writ petition filed by the respondent number 4 is allowed and the writ petition filed by the appellant is dismissed, my lord. Both are heard analogously, my lord.
Why did you go? What was your grievance?
My lord.
Why did you go before the learned single judge? What was your grievance?
Well, I filed a writ petition before the single judge because of the inter-se seniority dispute, my lord. Inter-se seniority dispute, your lordship has already held in a judgment that from the date of appointment. So from date of appointment, I was junior. But admittedly, I am not contesting that part, my lord. Here, my lord, due to the serious allegation leveled against the respondent number 4,
so he should be demoted or reverted without an inquiry.
Well, this is not a question of reversion, my lord, because
the allegations are not serious according to
allegations are very serious, my lord.
So very serious allegation, no inquiry should be held.
Yes, my inquiry.
Because allegation is very serious.
Inquiry is being held, my lord.
That's the law, sir.
But inquiry is being held, but inquiry is not completed.
The law is that if it's very serious allegation, no inquiry. No natural justice. That's the law.
Well, inquiry is being conducted, my lord.
With participation of that person, giving him an opportunity to meet the allegations against him.
Well, my case before your lordship is.
You answer this question.
Yes, my lord. Yes.
There are serious allegations against A.
Yes, my lord.
Internal inquiry is held.
Yes, my lord.
A does not participate. A should be proceeded against without any opportunity to him. That is the law, correct? Sure. And the more serious the allegation, no inquiry at all involving him. That's the law.
No.
What is the law?
No, my lord. He should be given a fair opportunity. Lordship is correct.
Isn't that what the learned single judge is saying?
But, my lord, till that inquiry is completed, my lord, he should not be kept in charge of the principal in charge because he will influence, my lord. Because he will return to the financial capacity and administrative capacity of that college, my lord. But who has made a complaint? The alumni, the students and the guardians, my lord. But he was selling fake certificate, which is a very serious allegation, my lord.
So the more serious you go on saying you have used the word fake certificate at least 10 times now. And you want to argue that, sir, don't give him even a shred of an opportunity to meet that allegation. This is your argument. And you want the High Court to accept it.
But
please, just listen to yourself first.
Yes, ma'am.
How absurd it seems, right?
Well, a fair opportunity should be given to the respondent number 4. But till that inquiry is conducted, till he comes out as clean, my lord, he should not hold that post of principal in charge, my lord.
Yes.
But this is my case, my lord.
What is this college?
Well, aided college, my lord. It's an aided college, my lord. Receiving block grant from 2009, my lord.
But in that writ petition filed by him, were you a party?
Yes, my lord.
Why are you a party in that writ petition?
My lord.
In the writ petition filed by respondent before,
yes, my lord.
Why were you a party?
Because, my lord, after he was divested from the principal in charge post, I was allowed to function as principal in charge, my lord.
So you are now saying you also do not want to be there. Somebody should be there.
No, my lord.
No, I'm just saying who will be in charge? That will be in charge.
That is not my. As I am continuing, my lord, I want the status quo should be maintained till.
That's the point.
Till the inquiry is.
That's the whole point. That's the whole point.
Till the inquiry is completed, my lord. That is, if he comes out clean, my lord, I am ready. I will leave my position, my lord.
Right. You say the challenge of the present writ appeal is to an order dated 24th February 2023, passed by the learned single judge, allowing writ petition civil 18092 of 2018 filed by respondent 4, and directing and setting aside an order dated 12/11/2018 passed by the Deputy Director, (GCB), Directorate of Higher Education, Odisha, divesting respondent 4 of all responsibilities of principal of the Biju Patnaik Degree College of Science and Education from Jaydev Vihar, Bhubaneswar, and instead approving the appointment of the appellant, who was the next senior most approved teaching staff, in his place as principal in charge, secretary, with powers to make all financial transactions on behalf of the college. Paragraph. While setting aside the above order, the learned single judge has further directed that full stop. The reason for the learned single judge setting aside the above order was that although an internal inquiry was conducted by the college, there was no opportunity granted to the respondent before to meet the allegations against him, and therefore the impugned order is in violation of the principles of national justice. The learned single judge has further directed that while the respondent 4 should be reinstated as in charge principal within 2 weeks from the date of the communication of the order. The respondent 4 should render full cooperation to the concerned authorities in the conduct of the inquiry in relation to the allegations leveled against him. Paragraph. This order has not been implemented yet.
No, my lord. It has not been implemented and the appellant is continuing as principal in charge, my lord.
How come? How is that possible, sir?
Yes, my lord. My lord.
Within 2 weeks, they were supposed to.
But it has not been implemented, my lord.
All right. You say, having heard learned counsel for the appellant, the court is of the view that the impugned order, that the order which divested the respondent before his powers as in charge principal, and as a result of which he began functioning once again as lecturer with the present appellant who was junior to him being the in charge principal, could not have been issued without affording the respondent before an opportunity of being heard, particularly since the allegation was of financial irregularities, which is of a grave nature. Paragraph. Counsel for the appellant then submits that even if an inquiry is now held, inasmuch as the respondent before would be the principal in charge, he may not permit the inquiry to be conducted in a free and fair manner. Paragraph. It will be for the college authorities to ensure in the fresh inquiry that respondent before is not able to influence the outcome of such inquiry by the college authorities as well as the Director of Higher Education to ensure that the outcome of the inquiry will not be unduly influenced in an unfair manner by the reinstatement of respondent before as in charge principal. Stop. Otherwise, the principle on which the basic legal principle on which the learned single judge has interfered with the order dated 12th November 2018 passed by the Director of Higher Education cannot be faulted. Paragraph. With the above clarification, the court declines to interfere with the impugned order of the learned single judge. The writ appeal is accordingly dismissed.
Item number 7.
May it please your lordship. My lord, here the petitioner association is a registered association of allottees who were given apartments by the OP number 1 builder. Now, the petitioner before your lordship seeking or challenging the continuance of the appellate proceeding on 3 grounds. Mainly the maintainability. The appeal could not have been maintained as such. Second, a so-called compromise is being thrusted upon the allottees by the learned appellate tribunal, which is dehorsed the statutory provision. There is no statutory provision of such a compromise being effected upon, but it is being insisted to be adopted by the appellate tribunal on the association. And thirdly, indiscriminate adjournments are being granted and the continuance of proceedings since 2022 January till date, whereas the statute provides for 60 days to be completed, the appeal to be completed. Now, the brief facts in nutshell, my lord, is 2015 a scheme was floated by the OP number 1 for allotment of apartments for intending purchases. Now, 2015, they had stated that
What is the order against which you're?
this is the entire proceeding and which is under challenge before your lordship, my lord. The entire proceeding, because it is against the statutory provision and the so-called compromise which is being thrusted. That is
What is the compromise being thrusted? Let's see which is the order which is thrusting
Yes.
some compromise in you.
the compromise, my lord. The brief fact, only one thing I'll point out, my lord, before the compromise, that the appeal could not have been maintained because this was a second appeal and the first appeal preferred against the complaint which had been made had been dismissed already for non-prosecution. Without restoration of that appeal, a second appeal was preferred against the execution order, which was entertained. Now, your lordship comes to the orders which have been passed. That is under Annexure 10, starting from page 115, my lord.
Let's look at 132, page 132.
My lord.
You are appearing for whom? The association.
Yes, my lord.
Ah.
In fact, I was the intervener before the
That is for the Allottee Association.
yes, Allotee Association.
And the appellate before the Oriat is the builder.
Is the builder OP number 1 here?
All right. Just read the page 132.
Yes. May I read it, my lord?
Yes, please.
Due to COVID-19 pandemic, the appeal is taken up through video conferencing. Mr. M.S. Srinivas, the managing director of the appellant company, Mr. A. Mr. Leonard,
Let's skip
counsel.
all that, sir. Come to the main thing.
Yes. During course of hearing, a dispute has been raised by the learned counsel appearing for the association that in spite of the compromise entered into between the association and the appellant has not paid the amount to any of the allottees and the payment has been made in a selective manner which is not proper and justified. It is submitted that as per the terms of compromise, the appellant is required to pay all the allottees equally in order to give effect to the compromise and settle the matter amicably. Mr. A. Rath, learned counsel, my lord, here is our stand. That is the intervener who is the for the association. Mr. A. Rath, learned counsel, appearing for the intervener, submits that several allottees flat do not intend to take back the amount with interest as has been indicated in the compromise petition, and the said allottees want the possession of the completed flat on their for their own use. Mr. Srinivas, appearing in person, submits that several allottees have already been paid. The amount in terms of compromise and bank draft in respect of other allottees is ready, but they are not coming to collect the same. This, for a moment, I'll pause. This is a complete lie which was made before the learned tribunal. Because all this
finish reading, then you make all your comments, sir.
Grateful, my lord. Therefore, the compromise is not being worked out. Considering the submissions made in view of the dispute raised by the parties, Mr. Srinivas, the appellant is directed to file a list of allottees who have already been paid the amount in terms of compromise and also file a list of allottees whom he is ready and willing to pay as per the compromise, for which the bank draft has been prepared or is being prepared. Let such list be filed within 2 weeks with a copy of the learned counsel appearing for the association as well as the intervener. Put up this matter 2 weeks after. Thereafter, my lord. May I go ahead with the next order?
Yes, 16-123.
16-123.
Yes.
Due to COVID-19, the main extract here, my lord. Mr. M.S. Srinivas, the managing director of the appellant company, submits that he has already filed the list of the flat allottees who have been paid in full final settlement as per the terms of compromise. It is further submitted that a fresh list of flat allottees who are going to be paid an amount in terms of the compromise has also been filed today, along with extra copies.
Is there a compromise with an association? And are you a member of an association?
I'm the petitioner is the association itself which has come before your lordship. It is represented by the secretary. Before the complaint.
Where is that compromise which is being spoken of? Which page is that?
That is Annexure 8 at page 97.
Have you resiled from this?
No, there is no question of resolution because the petitioner association was also not interested for compromise.
No. Have you not signed this compromise, sir?
No. It was only this was given to the learned before the learned tribunal to show that the petitioner is the opposite party is ready for a compromise. It has never been signed or filed through an affidavit.
Come to 107.
My lord.
Who has signed this?
Advocate for the appellant and advocate for the respondent. That is the joint secretary who has signed it. Joint secretary was never the person who represented the association. He was just an allotee. Along with a few other allotees, he was made a party.
This is 21/9/22, correct?
Yes.
Have you filed an affidavit after that before the ORI Act saying this is an unauthorized, we don't agree with this compromise?
Yes.
Where is that affidavit?
That is my intervention petition itself.
No. Intervention.
And there is another affidavit.
Sir, if you're a party, we're supposed to do intervention.
No, I was not made a party there before
Sir,
the ORID. It is the joint secretary who was made the party. That is my case, my lord. The joint secretary could not have represented the association in view of the bylaws and.
Where is your application for intervention? Where's the copy for application?
Yes, my lord. The intervention application is Annexure 7, page 87 to 96.
Oh, the cost title of case itself, just see Seven Hills Estates Limited versus Seven Hills Flat Owners Association. That is respondent number 1 in the appeal.
Yes.
Huh.
But it was represented.
And in fact, the intervener is one Harish Chandra Patnaik,
who is the secretary.
So obviously there is an internal dispute between the secretary and joint secretary.
So that is why
you were trying to say that the association is the intervener, which is a completely wrong statement. The association was already respondent number 1 in the appeal. The intervener was one Harish Chandra Patnaik.
No, here I'll clarify, my lord. The association was the intervener because.
Sir, come to page 89. This is your intervention application.
Yes, my lord.
Who's the intervener? Tell me, sir.
The appellant has filed the.
No. The cost title above that. Who's the intervener?
The intervener. However, the intervener respondent is the secretary of the Mesa 7 is Flat Owners Association.
Sir, kindly answer the question properly.
My lord.
You have described some intervener in this intervention application.
My lord.
Please read the description of the intervener. From the cost title.
From the cost title, my lord, it is the cost of the Seven Hills. Thereafter, intervener respondent is Harish Chandra Patnaik. That is
so
what
why do you make a wrong statement that the association is intervener? When I repeatedly asked you who's the intervener, you kept saying association is intervener.
No, because in the
is that not an incorrect statement that you're making?
My lord, I bow down to your lordship in that effect. In fact,
so this is obviously a fight between you as secretary, because as secretary you filed an individual intervention application. And is it not right that respondent number 1 is the association?
No, in fact, the respondent number 1 was the association, but it was represented by the joint secretary.
So obviously, therefore, there is a fight between the joint secretary and you.
Now there is no fight.
Is there a resolution of the association? Show us a resolution of the association that they don't agree to this compromise.
Yes, my lord.
Where is that resolution?
That is, my lord, at Annexure 6 series 81 to 86.
What is the date? No, that they don't agree with this compromise.
Yes, that is there in the one of the minutes of the meeting. That is there also, my lord.
So the compromise is dated, this Annexure 6 is dated 29 July.
Before it could be placed before the...
Sir, 1 minute. This compromise at Annexure 6, are you seeing that?
Yes,
page 83 is 29th July 2022.
My lord.
Correct? The compromise before the ORI Act is dated. Where is that document? Which annexure is that?
This was filed late before the audit.
Sir, kindly answer the question. Which page is the compromise?
97.
And what date is that?
97.
Come to page 109.
Yes.
What date is that?
21 September 2022.
So this compromise is subsequent to your minutes of the meeting,
Yes, ma'am.
correct? Now,
Ma'am.
is there another minutes of your association after, please listen carefully, sir,
My lord.
after 21st September 2022, stating that as an association, we do not agree to this compromise? Where is that resolution?
May I submit, my lord? In fact, this resolution, this settlement was outrightly rejected in the first meeting itself in the resolution that
So
If-
that compromise was effected on 21st September 2022.
yes, but
There's no question of rejecting
here, my lord,
21st September 2022 before
my
21st
lordship may
September.
kindly bear with me because from the date, first
So
date,
you show me a resolution of the association after 21st September, which says we do not agree to the compromise entered into on 21st September 2022. Simple.
this compromise was never placed before the.
Where is your resolutions, your association's
I-
resolution to that
I
effect?
understand your lordship's question. Only one moment, your lordship may give me. When the appeal was filed, he stated about a compromise and took.
You forget what was stated in the appeal was filed, sir.
Yes.
When the appeal was pending before the Oriat, a compromise petition is presented on 21st September 2022. If you now say that you do not accept that compromise, please show a resolution of the association after that date stating that we do not accept the compromise. Very simple. I'm not going to repeat after this.
My lord, I have understood, my lord. This resolution which has passed now, it is a subsequent development which has taken place 5 days ago. There is another resolution of the AGM where they have discarded this. But before that, my lord, when the talk of compromise was going on, that compromise is not acceptable was passed in the resolution dated, my lord, on the month of May, when the appeal was pending and there was a talk of buyback scheme. That was rejected outrightly. Thereafter, it was given a shape and now the ORIT wants this compromise to be adopted. That is my case before your lordship. Whereas the entire association is not willing to take this compromise as a buyback compromise. And what the complaint petition states, that this apartments are to be registered as per the statute. This is the question of compromise now, my lord. And if your lordships want to see that the present resolution, which has my lord, disclosed that this compromise cannot be effected and the entire association does not want to adopt it, that has been passed only 5 days back. That I can produce with an additional affidavit, my lord.
You've not placed it on record. You knew today was the hearing.
It was 5 days back. Only the AGM has been conducted. That minutes will be available. I'll file it with an additional affidavit. And your lordship may kindly bear with me, my lord. This compromise which has been given a shape in this by.
What was the date of the resolution? This resolution which you're going to produce, where is that?
Yes, that date, my lord, was on 26th of March. 26th March.
So where is that resolution?
That resolution, I do not have a copy of that. I'll just produce. Because I didn't have the knowledge this matter would be listed today, my lord. I had not given a.
We are very sorry, sir, that we listed your appeal for hearing. We should not have listed it.
No, my lord, that is not.
I'm extremely sorry.
No, my lord, I may not be
sorry. I'm extremely sorry for having heard you for 20 minutes.
I would have collected that, my lord.
I'm very sorry to have heard
Yesterday night only next tomorrow, my lord, it may be taken up. I'll produce that. To 26th March.
Counsel for the appellant, when asked pointed questions, says that he did not expect the appeal to be heard today.
No, my lord, I'm so sorry, my lord.
Yes.
I should not have.
And that he is therefore not prepared with the documents he is expected to produce before the court in support of his submissions. Stop. List on 21st August.
My lord, shorter date, that is what. I'm
Item
so
number
sorry,
8.
my lord. I should not have made that statement. I just withdraw that, my lord. I'll
Yes.
put it on record tomorrow, my lord. Or any
Item 8.
shorter date, my lord.
Yes.
My lord, kindly, because
All
these
right.
are all least of allottees, those who have.
File an application. If you have that resolution, file an application for advancing the hearing. Yes.
Item
Let's
number
see how
8.
serious you are. And please don't waste the time of the court if you're not serious about these matters. There are enough matters that are being mentioned for listing. And if you don't want writ appeals that you have filed to be listed, you be prepared for this. Yes.
May I please, Your Lordship?
Yes.
And before coming to the impugned order, I'll draw my Lord's notice
Yes.
to page 68, annexure 12. Page 68, annexure 12. This was the direction.
Milord, delay has not been confirmed, Milord. Delay has not been confirmed.
What's the delay, sir?
Delay is about 398 days, Milord, for filing of the appeal.
Yes, sir. What's the explanation of the delay?
That I cannot say explain, but only point I can draw my Lord's notice. At least this in compliance to the direction of my Lords that I have shown my Lords that page 68. So, Lordship may say that was the direction of this honorable court, and in compliance to that direction, we have terminated them at page 61. And Your Lordship, that order was at page 60, annexure 12 was also challenged before the Honorable Apex Court. Some of them have challenged, and this has been confirmed before the Honorable Apex Court. I have annexed that order, that is at page 102. Your Lordship may remember that case. These are the Shiksha Sahayak appointed beyond the advertised vacancies. So Your Lordship had directed that Your Lordship annexure 12.
What does the impugned order do?
That 109, ma'am. Impugned order is page 99. That to count their past service, what has happened when they were terminated. Subsequently, another selection was made in pursuant to my Lord's direction. Declaring their earlier appointment as illegal, they were terminated. So Honorable Single Judge said that you count those past service towards seniority. Page 100, my Lord.
No, what happened in that Udit Kumar Babu's case?
Hello?
Just come to page 100, sir.
Yes, ma'am. Udit Kumar Babu, she is also similarly situated. He was also terminated.
No. What happened in that? You challenged that order?
That writ appeal was challenged. Your Lordship has dismissed that on the ground of limitation. That merit has not been gone in.
You will hear the same thing then?
This is the fact I have.
So how many? So is there any of the writ appeals that you filed challenging these orders which has been admitted by this court?
Yes, in this case, notice has been issued.
No. Other than
No notice has been issued.
only
confirmation
delay. Notice has been issued only on delay.
On delay, my Lord.
Has the division bench entertained any other writ appeal? Because there's a whole batch of matters.
No, my Lord.
No.
I don't know, my Lord. This is the first case I have come across, my Lord, because school, Your Lordship knows the school mass education were dealt by their councils now.
No, this 29/4/2004, what is that order? Where is that?
That I have brought my Lord's page 71. In compliance to that direction, my Lord, we have terminated them. Your Lordship, page 71.
So this was a general direction.
Yes, my Lord.
That's all right.
From the state.
That's
and
okay.
Both were.
So it doesn't mean that you don't follow the principles of natural justice while terminating.
Yes, my Lord. That is the case.
So you have not followed the principles of natural justice, sir.
Principle of natural justice.
No. This was a general order saying there are irregularities in appointments, and so No,
my Lord. What has happened? That the general order is that you have made appointment beyond the advertised vacancy and you confine it. Your Lordship, that's the order.
All right, let's see that.
May I?
Yeah.
Page 73.
73.
My Lord. On behalf of the state, a counter affidavit has been filed shown by the Joint Secretary to Government of Odisha and Mass Education, wherein it has been stated in paragraph that regarding recruitment of 15,682 number of Swechhasevi Sahayak, the state government has not asked for fresh advertisement in consideration of the validity of the select list for 1 year. The affidavit is clear and it requires no further delve into the contention raised by the parties. as it transfers that a circular issued in Annexure 5 is contrary to the guideline issued by the government and holding the field. There is also nothing to show by the state. Such a circular is issued in supersession with the government guideline, or nor there is any government decision in that regard. The relevant portion of guide is as follows. Select list will be valid for 1 year from the date of finalization. This will be 150% of the post advertised for the district. Therefore, the instruction issued to the collector by the Secretary to Government School and Mass Education Department under Annexure 5 is contrary to paragraph 5.4 of the guideline issued by the government. Accordingly, Annexure 4.5 is set aside. The opposite parties are that
Directed to the earlier
yes,
page.
madam, that
Come to page 72.
that page is
Right. It's there.
sorry, madam, that
Yeah. Directed to make
a fresh advertisement for recruitment further 15,000 number of posts. The person are at liberty to apply for the said post if they are otherwise eligible and their case may be considered along with others. The challenge of the clause 6.0 of guideline on the ground of their prayer to direct up to give preference to the erstwhile NAP advisor supervisor is not tenable. Because in my view, the clause 6.3 can by no stretch of imagination be termed as arbitrary, warranting the interference of this court. Accordingly, the prayer of the petition on this score is rejected. The writ application is partly allowed. During the course of hearing of this case,
No. So these petitioners are at liberty, and the petitioners there were not similar to the petitioners here.
yes, no.
Those petitioners did not get in.
Yes, madam. And the excess of then page 61.
No. So there was no direction in this judgment that they should all be removed. There is no direction that they should be removed. The only direction was issue a fresh advertisement.
That what has happened, Mala, they were beyond the advertised vacancy.
Maybe there are still other vacancies.
Your Lord's page, may I draw my Lord's notice, page 61.
Yes. No, this order of 14th May 2015, which you have challenged here, did you implement it? The order of 14th May. You have challenged the 14th May order here. Was there a stay of that order?
No, madam.
You have not implemented it?
No.
For 8 years, you have not implemented. How did you keep quiet for 8 years?
What is that? I am clarifying. In subsequent selection, they were selected. So they are continuing. There is no dispute, my lord.
Then why are you challenging this?
The only seniority part.
What is there for seniority, sir?
What?
You've all got back. You've all been selected.
Yes, madam.
We are continuing as service.
Then also more let them continue the seniority also.
Oh, what has happened, my lord? In compliance to that direction, they were terminated. Subsequently, they appeared in the recruitment test and they were reselected. So that part, that from the date of initial appointment to that termination period, they are counting.
Let's not interfere there. So the challenge in the present writ appeal, you say there is no satisfactory explanation for the inordinate delay of 298 days, is it?
398.
398 days in filing the present writ appeal. Going by the settled position in law, as explained by the Supreme Court in Postmaster General versus Managing Director Living Media Limited, and the subsequent decision in State of Madhya Pradesh versus Berulal, and a large number of decisions. The explanation offered for the inordinate delay is not satisfactory at all and cannot be condoned. Paragraph. Nevertheless, the appeal has also been examined on merits. Challenging the cancellation of their appointments by orders dated 11th November 2010 passed by the collector Subarnapur. The respondents had filed writ petitions in which the common order, impugned order dated 14 May 2015 was passed. Following an order dated 9th March 2015, passed in writ petition civil 1921 of 2010, bracket Udit Kumar Babu versus State of Orissa. The court is informed that by counsel to the learned additional government advocate, Mr. Pandya, that the writ appeal filed against the aforementioned order dated 9th March 2015 was dismissed by this court on the ground of limitation. Full stop. Paragraph. It is seen that pursuant to the cancellation of the appointment of the respondents, a fresh advertisement was issued, which was in terms of the judgment dated 29th April 2004 passed by the court in Writ Petition Civil 11748 of 2003. Bracket. Rishikesh Bindani, HRUSHIKESH Bindani versus State of Orissa and others, bracket. Pursuant to that fresh advertisement, the respondents again qualified and have been appointed and therefore are continuing in service. Full stop. Paragraph. Counsel for the appellant in the above circumstances states, appellant state in the above circumstances submits that they still want to challenge the impugned order of the single judge only because by virtue of the impugned order, the seniority of the respondents would date back to their initial appointment. Full stop. Paragraph. The impugned order was passed on 14th May 2015, directing the respondents to be given all consequential benefits by quashing the order dated 11th November 2010, by which their services were, their appointments were cancelled. Their appointments as junior teachers and regular primary school teachers under the Zilla Parishad was cancelled. Full stop. For more than 7 years now, despite there being no stay of that order, it has not been implemented by the appellant state. Full stop. The challenge to that order was also belated, with the delay not being satisfactorily explained. Paragraph. Since the only benefit that the respondents will now get is that the seniority will count from the date of the initial appointment, the court sees no reason why it should interfere at this stage. Full stop. Consequently, the court is not persuaded to interfere with the impugned order of the single judge. The writ appeal is dismissed both on the grounds of delay as well as on merits.
Item number 9.
None appears dismissed.
Item number 10.
In item 10, my lord, notice has issued to respondent 234 that it appears
Undelivered.
on
AD is not back.
May I take fresh notice to those?
What's the matter about? You are for respondent one.
I'm for the opposite party.
The
The
matter
case is, my lord,
is that matter relating the pension.
pension.
Hmm.
Taking into account the entire service that has been served by the petitioner, opposite party number here, the Honorable Single Judge had passed an order that should be counted for the purpose of pension. Now they challenge it here. That order has been passed pursuant to the pension rule that is being followed for the employees of the educational institutions, either private, aided, or they may be recognized institution. That service has been taken into account. Now they want to challenge that order.
On what grounds, sir?
Yes, ma'am. Only ground, my lord, that your lordship may turn to page 72 in the impugned order.
What's the delay here?
Delay, my lord. There is no delay, my lord.
Yes, there was delay.
No delay.
No, but-
During COVID period, so there is no delay.
My lord, there are 100 some days that delays are there.
Anyway,
During
lockdown
COVID
period.
period.
No, prior to COVID, my lord.
Order dated 28 to 2020. order dated 28 to
It's
2000.
COVID period, sir. It's COVID period. All right. Delays condoned. Now you tell us on merits. Where
Yes,
is the impugned order?
It might page 72.
Yes. Come up 74 bottom, sir.
I'm reading of the third paragraph. The sum and substance of the argument of learned senior counsel for the petition is that the petitioner having the requisite qualification was selected and appointed as a lecturer in logic and philosophy by the Secretary of Loknath Mahavidyalaya Patkura and joined the said post on 10/1/83 along with petitioner another person, namely B.C. Jena, joined as lecturer in logic and philosophy in the said college. Thereafter, a number of were filed by the regard to approval of the appointment against the first post of lecture in logic and philosophy. Ultimately, Sri Jena was taken in against the first post and recommendation was made to approve the appointment of the petitioner against the second post. Number of recommendations were also made from the side of the governing body opposite part number 2 college, also from the side of opposite part number 2 to the government for approval of the appointment on the ground that from the date of appointment the petitioner has been continuing and discharging a duty. Ultimately, the government passed an order on 8/10/99 adjusting the petition against the vacant direct payment post in Bhimabhai College in the district of Sambalpur, where the petitioner joined 13/11/99. While working there for certain period, the petitioner transferred to 2007 and thereafter retired on 30/4/2014. After retirement of the property department college submitted the pension paper to the authority. However, the authority calculated the period of service of the petitioner from 13/11/99 to 30/4/2014 for the purpose of pension. That period, why that period has been counted, Lordship then turned to page 74. The court perused the record and went through the provisions prescribed under Odisha Aided Educational Institution Employee Retirement Rules 1981. The joining and discharging of duty of the petitioner from 8/1/83 till was not disputed by any of the parties. Admittedly, the petitioner has performed his duty in the above mentioned college. A number of recommendations have been made either from the side of governing body or from the side of the director of higher education for approval of the appointment of the petitioner. The opposite part number 5 has also submitted the pension paper indicating the period of service from 8/1/83 to 30/4/2014 and also complied all the provisions made by the opposite part number 2. Rule 6(1) of Odisha Education Institutional Employee Retirement Benefit Rules prescribes as follows. In computing the length of qualifying service of an employee retiring on or after the 1st day of April 1982, all previous service except those rendered prior to his attaining the age of 18 years, whether temporary, officiating, or permanent, either in one or more than one recognized educational institution, shall subject to the condition specified in sub-rules 1, 2, 3 taken into account for the purpose under these rules. By applying this rule, Honorable Single Judge has allowed the pension. I'll draw my lord's notice. I have annexed that rule also. First, I'll draw my lord's notice, page 51. Why that period has not been counted? I admitted fact he was appointed against a post that not existent in that college. He filed several litigations and lost in all the cases. In one case, this Honorable Court had directed to file a representation before his authority, before the governing body to consider his case. So he filed a representation before the director.
If he served 31 years, why can't he count his past service?
That his continuance is not against any existence post.
All right.
That is the entire dispute, my lord. Government, considering it on humanitarian count, has adjusted him. Yeah, last time I see page 51.
Do these people have a choice, sir? Do these people have a choice?
No,
when you are given an appointment letter, do they
state.
start asking that person who gave the appointment letter, do you have a sanction post?
No, he is not a government employee. He is a management employee. That's the entire problem. He is a
So why
management.
should the person suffer? He has
He's
served 31 years in institution.
a management employee. At that point of
Whatever employee, sir, he's worked for 31 years.
at that point of in that institution, there is no post of second post of logic.
So people should return their appointment letters saying, because you don't have a sanction post, I refuse the employment. It's impractical.
Management has committed
It's
mistake.
impractical.
Management has committed mistake.
So who should suffer?
So
If management has committed a mistake, the employee should suffer.
no, that management will be responsible for that. Here, my lord,
Then you
pension,
figure out, you
government,
recover it from the management.
we are paying the government is only
So
paying
you
the
recover it
pension.
from the management then.
So
Why punish this employee?
in order to accommodate him, we have adjusted in 1999. Your lordship,
Somebody else pays the price. This is the whole problem. According to the management made the mistake, right?
sorry, my.
If the management made the mistake, why should the employee suffer?
Because we accommodate that employee for the mistake of the management that his post cannot be approved.
Yes.
And we accommodate him and approved him. And you also may see that another clarification we have issued that as per their clarification, you also that page 57 is the next annexure 1 of the writ appeal.
Yes.
This is the clarification basing on which you are.
No, but seriously, why can't you make the management pay? If it is a mistake of the management, why can't you make them pay?
My lord directed to consider his representation and for adjustment. Accordingly, we have adjusted in 1999.
There was a sanction post against whom.
Not in that college. Not in that college. In another college, we have adjusted.
Wherever, sir. The question is that he's been continuously serving.
At the clarification, you'll also see at page 17. That clarification says, you'll also see page 17.
Yes.
I am directed to say that all the benefits are provided to the employees of from the date of approval of the post computation of length of college, it will be taken from that date. So the post, from the date of the approval of the post, we have to compute it.
Yes.
So the post is approved on 99.
No, but where does it leave the employee really in all this? He just gives up all those years of service which is rendered.
This is the clarification we have issued, and because we are paying pension. Prior to that, they are approved. They are paid.
No. 14 years. How many years of service is chopped off? 14 years.
31 years of service.
No. For the purpose of pension, they're recognizing 14 years.
They calculated 14 years, 8 months. But
it should actually be 31 years.
31 years.
That's what. So nearly 17 years gone.
Nearly 17 years.
Why should he give up 17 years of service?
As per this provision, that period, approval period, is to be counted, my lord. You'll also pay 17. This is the provision. Which period?
Pension insist
this is the provision.
Not a provision, it's only a clarification. It's a clarification. It's a letter written internally.
Clarification, we have to grant pension from the date.
How do you interpret 6.1? Let's come to rule 6.1 now.
Yes, but our interpretation in 6.1 is that continuous is non-existent post. It cannot be termed as temporary or permanent.
No.
In a the post, there is no post that cannot be termed as a temporary service. And he has approved by lords and lost his case. That he cannot be approved. That was his case. He cannot be approved against that second post.
Where is that order passed in the writ petition?
That he has that I have given my lord that page 51. He has admitted that facts.
No counter was filed before the Honorable Single Judge. Now he wants to praise all these things. No counter was filed. That is the case of the Honorable Single Judge. You admitted whatever stated in the writ.
Page 51. It starts from page 50. I challenge that order of Director of Higher Education and the Honorable High Court of Orissa by filing a writ application bearing OJC number 8696 of 92, which was unfortunately dismissed by this Honorable Court. Thereafter, the governing body recommended my case against the second post of in logic and philosophy. The Director of Higher Orissa, on receipt of the offers and upon verification of the records, in its turn recommended my case for approval of my against the second post of lecturer in logic. But when no action was taken to accord my appointment against in logic, I was compelled to approach the Honorable High Court of Orissa. The Honorable High Court directed the state government to take a decision in the but unfortunately, notwithstanding the efforts to direct the state government when no decision was taken, I was compelled to approach the Honorable Court by filing a contempt. During pendency of the contempt, the state government communicated the employer saying that workload of college in question did not justify for second post, although at that time verification no such objection was raised. However, I again challenged the said order by filing another bearing OJC number 9496 of 95. But unfortunately, again I lost in the High Court, Honorable High Court, and the Honorable High Court did not entertain my case on the ground that workload of the aforesaid college did not justify for the second post. However, the Honorable Court of Orissa observed that I may pursue my remedy with my appointing authority, the governing body of the college, for adjustment as a lecturer. That it is pertinent to mention here that when the workload of the college as per the decision of the does not justify for the second post, that there is no scope for the governing body to consider my case for adjustment as lecturer in logic and philosophy. He has admitted. And then he filed a representation before the director. And your lordship directed to consider his case emphatically. In compliance with this direction, we observed them.
No, where is this direction issued by the court? To consider him?
That is OJC number 9/2646 of 97.
Where is that order?
That order is not, but it is reflected at page 56 in page 56. This is the case, Your Lordship.
It's only one person, is it?
Yes.
Then we'll
So,
confine it.
I have submitted before this is the case.
Then we'll confine it to the facts of the case. No need to go after. You see, the challenge in the present petition by the state of Orissa is to an order dated 28 February 2020.
And this will not precedent for other cases because
That's right. That's in WP Civil 12258 of 2018, asking the appellant to refix the pension payable to respondent 1 by taking into account the service rendered by him between 18 January 1983 to 30th April 2014. Stop. In other words, paragraph. The background facts are that the respondent number 1 was initially appointed on 18 January 1983 as lecturer in logic and philosophy by the Loknath Mahavidyalaya, Patkura. Another person, Shri B.C. Jena, also joined as lecturer in logic in the said college along with respondent 1. Full stop. When their appointments were not being regularized, writ petitions were filed in this court. One such petition was OGC number 1092 of 1995, whereby a direction was a direction was sought to the state government to take a decision on the proposal submitted by the Director of Higher Education to the state government for approval of the appointment of the respondent one in the second post of lecturer in the logic department of the above college. Following orders, an order dated 30th June 1994 in OJC 3874 of 1994, which was in a similar case. This court, by its order dated 13th March 1996, disposed of OGC number 1092 of 1995. Directing the Department of Higher Education to act on the above direction of recommendation of the director for approval of the appointment for respondent one, open quotation, in the second post of lecturer of logic department of the Loknath Mahavidyalaya, Patkura. Unquote. However, this order was not given. Sorry. However, ultimately the writ petition came to be dismissed when the court was informed. Dismissed on 1/11/96 when the court was informed that the workload in the said college did not justify the creation of a second post of lecturer. Stop. Paragraph. Respondent one then made a representation that he should be adjusted as lecturer in logic and philosophy in any other post, in any other college. Full stop. When no action was taken thereon, respondent one filed OGC number 2646 of 1997, which was disposed of its court on 8 July 1997, permitting the petitioner to make a representation to that effect. Stop. Paragraph. Pursuant thereto, a representation was made by the respondent one on 7/8/1997. Stop. Acting on it, an order was issued by the Department of Higher Education on 8/10/1999, appointing the respondent one, open quotation, against the vacant direct payment post of Bhima Boy College in the district of Sambalpur. Unquote. Respondent one joined the above post and ultimately retired from that institution on 30th April 2015. Paragraph. When it came to sanctioning the pension of respondent one, the period served by the respondent one till 13/11/1999 was treated as single quotes non-qualifying service in court. Paragraph. aggrieved by the above decision, writ petition civil 12258 of 2018 was filed by respondent 1, in which the impugn order dated 28th February 2020 has been passed by the learned single judge, allowing the prayer of the respondent 1 to count his entire period of service from 1983 on to 12, including the period from 18/1/83 to 12/11/1999. Full stop. The learned single judge relied on Rule 6(1) of the Orissa Aided Educational Institutions Employment Retirement Benefit Rules 1981 (1981) rules, which reads as under. Take from page 75, top paragraph. Mr. Kuntia, learned AGA, points out that the above provision would apply only to a sanction, only to the services rendered in a single court sanction post, whether temporary, officiating, or permanent service. If the post itself was not sanctioned, the service rendered in such as such without a sanction post could not be counted for the purpose of pension. So for this purpose, he refers to a letter dated 1st February 2016 issued by the Joint Secretary to the Government in the Department of Higher Education, which reads thus. Just take the letter portion in page 17. Paragraph. In response to a specific query whether the respondent 1 should be made to suffer for having been employed by the college at Patkura without there being a sanction post, Mr. Kuntia volunteered that it was the mistake on the part of the management to have engaged respondent 1 without there being a sanction post. Full stop. In other words, it's because of the mistake of the management that respondent 1 has to give up almost 16 years of service rendered by him in the Patkura College for the purposes of qualifying service for pension. Full stop. Paragraph. The facts of the present case are indeed peculiar. Although the respondent 1 does not succeed in the writ petitions filed by him in the court for being accommodated against a sanction post, he ultimately did get accommodated by the order passed by the Department of Higher Education, again pursuant to a direction issued by this court in a writ petition filed in an order dated by virtue of an order dated 21st, sorry, order dated 8 July 1997 in OJC number 2646 of 1997. Paragraph. respondent number 1, who's nearly 70 years old now, has had to pursue this litigation for getting his pension refixed. After having rendered 31 years of service. Stop. It is impractical to expect him to resist an appointment order issued to him way back in 1983 without having any means of knowing whether there was a sanction post against which he was being appointed. Stop. In other words, he should not be made to suffer for no fault of his. Full stop. Paragraph. At the same time, the court does see merit in the contention of the appellant that service rendered, whether in temporary or officiating capacity, can be counted only if the post is a sanctioned one. And therefore, Rule 6, bracket 1 of the aforementioned rules will not really come to the aid of respondent 1. Paragraph. Keeping in view the peculiar facts of the case as noted herein before, the court clarifies that the impugned order of the learned single judge will not be treated as a precedent and will be confined to the peculiar facts of the case. Full stop. The writ appeal is disposed of in the above terms. Stop. Now that the impugned order of the learned single judge, insofar as the respondent number 1 is concerned, is left undisturbed, it should be implemented by the appellant within a period of 8 weeks from today by issuing the appropriate orders refixing the pension of respondent number 1. We'll stop. The interim orders vacated. The writ appeal is disposed of.
Item 11.
May I please your lordship that the learned and single judge disposed of the writ petition running page 14, directing stay of disciplinary proceeding during pendency of the criminal trial. The very same day the writ petition has been disposed of. It is settled law that both the criminal proceeding and
no, but anyway, very first day, sir, and it can be sent it back.
My lord, the department, yes, very admission stage, my lord.
So let it go back, let them file a reply and all that. The impugned order was passed by the learned single judge on the very first day. Without an opportunity to the present appellant to file a reply to the writ petition. On that short ground, the order is hereby set aside. And writ petition civil 733 of 2022 is restored to the file of the learned single judge, the roster bench, where it will be listed for hearing on 23rd August. The appellant state will file its reply, Paravis reply to the petition by 14th August. And the respondent petitioner is permitted to file a rejoinder thereto, if any, on or before 23rd August. No further time will be granted to either party for that purpose. The learned single judge is requested to proceed with the hearing of the petition on merits and dispose it off as expeditiously as possible.
May I pray, my lord, till then interim protection, my lord, because they will go on with the proceeding since both the proceeding and criminal charge are identical, like accurately identical.
That it will be restored along with the interim applications. You say the file along with the interim application.
Since your lordship fixing August, my lord,
yeah,
during interim they can proceed with.
Let's see, sir, what it.
Or I may be permitted to.
Yeah, you are already permitted. It's already restored to the file of the learned single judge, sir.
Yes.
Item 12.
Item 12, 13.4. 13th April.
Item 13. 13, my lord, lordship has kept similar matters to 25th of April.
Right.
Item
Right. 25th April.
Item
single
14.
day disposal. What I pray, my lords, it's a single day disposal, my lords. Let it go back. My lords, I pray similar orders which has been passed in writ appeal number
Yes, sir.
660 of 2022.
All right.
Item number 13 and item number 44. I'm praying,
All right. Same order.
sir.
44.
Item number 13 and 44.
All right. What data is? All right.
Grateful, my lords.
Item 14.
Is
Item 14. sir.
Kuntia. 14 is technical education and training.
Primarily, you'll pass over. Sir. In item 13 is the first day disposal. Lordship,
You're appearing 14.
Yes, my lords. My
14
name is,
also.
I have filed a caveat, my lords. In 14, I have filed a caveat.
So again, it's first day disposal.
It's a first day disposal, my lords, but in the minutes, because of the warrant of the CCR, the case of the petitioner for promotion could not be considered, my
no,
lords.
that cannot be done because he's not belong to that cadre and he cannot be considered for promotion against the post of establishment officer. So direction to supply.
Well, since it's a first day disposal,
So let it go back.
That I'm saying.
Yes.
Let it go.
So same order is the last one. That is, it's the 23rd August. Similar. Order. Same order.
Item 15.
May please, your lordship. I'm selling the single judge judgment dated 31/5/2022 in WPC number 27602 27613 and 2021, my lord. Matter is that the PG department of super specialist degree concerned board of specialist and PCM guideline 2 years experience
Only
training.
yesterday or day before this matter came up? Only yesterday or day before this batch was there, sir? Another batch. This is a batch of matters, correct?
My lord, my lord.
Only yesterday or day before we had this. What is the name of your appellant?
My lord, yes, earlier my lord,
Vishwajit Kar. I think there was an appeal filed by this Chinmay Rashmi Ranjan Mahapatra. That matter. No?
No. In that matter, this matter also to be directed to that.
What matter? When was the date? We've already given a date for this to be listed along with that.
I already read appeal number 872/2022, my lord. Order dated 28/9/2022.
28?
22. 28/9/2022.
What is that order? 28/9. Show me the 28/9 order. That's why yesterday we kept asking for that order. Dismissed. All right. Just keep this order. Because yesterday we should have passed this order. When did we fix that matter? In writ appeal 872 of 2022, bracket Dr. Mohanlal Khadia versus State of Orissa. The present appeal is dismissed. Just keep this on. Thank you.
Obliged.
Item 16.
16 and 17 in the meantime that order has been implemented in infructuous.
All right. Disposed of, dismissed as infructuous.
Item number 18.
18 मतलब 14th. That's similar to item.
14 September.
No, that's similar to item 12.
13th April.
13th April. All right. 13th April.
Item 19. 19 lordship have kept similar matters to 11th of
July.
May. Yes.
11th May or July?
My lord, 11/5.
11/5.
Yes, my lord. Item number 20. 20, my lord, 8/8, my lord.
8th August.
It's the outsourcing matter, my lord.
Right.
Item 21, 20 and 21 same, my lord.
All right.
Item number 22. 22, my lord. This is with regard to data entry operator, my lord, on contractual basis seeking regularization. Here, my lord, lordship have reserved the order, my lord.
It's my only one submission, my lords. My lords, so far as it relates to respondent number 1, my lords, that is Kedarnath Mantri, the order may not be applicable to that respondent number 1 only, my lords. Because in the meantime, he has left the job, my lords.
All right. You see, there are 16 contesting respondents, of which respondent 1 is stated to have already resigned. Submissions have been heard on behalf of the counsel for the appellants as well as contesting respondents 2 to 16. Orders reserved.
Grateful much.
Be pronounced along with it.
Grateful much.
Item 23.
23, 24, 25 outsourcing 8th August.
8th August.
Item 26.
May I please, lordship, another writ appeal number 1187 arising out of the self-same order is pending, madam. Let it come both next week.
All right. List along with liberty to file review. Writ appeal 1187, 2022. On 2nd May.
I am for the opposite part number respondent 1.
Right.
So more appeared and directed to copy survey appeal.
Answer. Item 27.
None appears dismissed.
Item 28. 28, lordship have kept to 5th of May, my lord.
5th May. All right.
Item 29. 29, 30 and 31, my lord. This is regarding grant of benefit of revised scale of pay. My lord, we have withdrawn similar matters to with the liberty to file review applications.
All right. Got a copy of that order?
My lord, I shall provide by
All right.
during lunch.
All right. With liberty to file it. Right.
29, 30 and 31, my lord.
All right.
Item 32. 32, lordship has kept the similar matters to 38, 2023.
Rehabilitation assistance. All right. 30th August.
Item number 33. 33, my lord, 11th of May, my lord. There's a vigilance case, seal cover matter.
11th May.
My lord.
Right.
Item number 34.
34 workers employees 14 September.
All right.
I may be excused. Item 27.
Tell us. Tell us.
Yes.
27.
That is this is the writ appeal against the order of the Honorable Single Judge. The prayer of the writ petition was twofold. That is publication of the result of the NIS. This is the training qualification, and subsequently on the basis of the result publication, the petitioner service may be regularized. The Honorable Single Judge, my lord, they only touched the regularization part, but did not touch to the publication of the result, where the petitioner has appeared, successfully appeared, taken admission by the sponsoring the government. He was a Sikha Sahak, was engaged as Sikha Sahak, and the basic qualification, that is BA with training qualification. So he was an in-service candidate. He was sponsored and already taken admission in the NIO. There is the National Institute of Open Schooling, and successfully appeared in the examination. His result was published, but subsequently this is the not published, and when the
application was filed for issuance of the certified copy was not given. That's why he came before this honorable court. But this honorable court only reflected that a service cannot be regularized because having that is no qualification. But is that training qualification which he has appeared successfully, that was not published. If the result was published, then he is eligible for regularization. This part only, my lord, this is the honorable single judge, your lordship see, this is paragraph 10. Only the your lordship's paragraph 10 of the judgment or the order, that is what the honorable, that is my lord. And may I be permitted to read, my lord? Yes. There is a paragraph 10 of the order. Had the learned counsel for the parties, the very engagement order issued in favor of the petitioner clearly reveals at clause 18 that in case of untrained candidate whose engagement will be renewed beyond 31/1/2015 shall have to acquire CTBED training qualification within March 2015. As per the stipulation made in the right to education.
All right, sir. Counsel for the appellant submits that there were two prayers in the petition. One was for regularization, whereas the first prayer was for a direction to the respondents, open petition, to publish the result.
Yes.
Unquote of the selection, is it?
In the read petition also, annexers, there's the admit card, everything, my lord. Annexer, that is page 14 of the read petition and 22 of the read appeal.
No. Just come to para 5 of your petition. Come to para 5 of your petition.
Para 5 of the read petition.
Page 13, running page 13 of the appeal.
My lord. Para 5 read petition.
Para 5 of the read petition.
Yes, my lord. I'm there the petitioner after admission into course appeared in the examination during 2019, but the result as published was withdrawn by the NIOS authority for ground that the petitioner does not possess 50% marks in close to examination. But it is he has already passed degree qualification. That is the close to qualification is not. There is a degree qualification on the basis of which he has already taken admission. Your lordship see in the read petition had taken admission 2 years course.
Sir, I don't think you're in a mood to listen to what I have to say, so I'll just ask my brother to tell you.
Yes. Close to.
Which is the result which you want to be published?
Your lordship see the result NIOS, there is diploma in training. There is your lordship see annexer 3 of the read petition. There is was the result was published. Your lordship see this page 23, that is annexer 3 of the read petition. The result was once published, thereafter withdrawn.
But this is the same result.
And without asking any counter, my lord, from the opposite parties, the read petition disposed of.
In fact, when you have secured less than 15% in the +2, how can the result will be published?
That is the he has passed the degree BA qualification. Your lordship come to that is the gazette notification. It is gazette notification of the government of India. That is the degree. That is your lordship see. That is the basic qualification. Your lordship see page 17. Page 17. That is the class VII, VI to VII, BA, BSc with diploma qualification. He has already passed BA qualification. And the only requirement is diploma, 2 years diploma course. And also accordingly, he was sponsored by the as a in-serviceman by the government, and also accordingly, he was taken admission. He was by the NIO as for and prosecutor study for 2 years. 2 years. There was no restriction at that time, and result was published. Thereafter, Your Lordship, only after asking there is a counter from the opposite parties, the NIOS, then this will be, my lord, only adjudicated without asking and without issuing notice, asking any counter from their and only dismissed at the admission stage.
Correct. All right. You say that there were the challenge in the present writ appeal. We do not agree with you, sir. The challenge in the present writ appeal is to an order dated 11th August 2022, passed by the learned single judge, dismissing the appellant's writ petition civil. (16376) of 2022. Stop. There were 2 prayers made by the appellant in the aforementioned petition. One was for declaration of the result of the diploma in elementary education examination conducted by the NIOS during 2019. Full stop. The second was regularizing for regularization of the service of the appellant upon his completion of 6 years of service as Shiksha Sahayak, as well as junior teacher (contractual), having been appointed as such and working at the Kunjamura Upper Primary School, Batagaon, in Sambalpur district. Paragraph. The learned single judge has noted how initially the appellant was appointed under the physically handicapped category as Shiksha Sahayak, although he was an untrained candidate at the time of recruitment. But he was thereafter instructed to take admission online and acquired the training qualification through the National Institute of Open Schooling, (NIOS). Stop. The appellant was admitted to the training course and was issued an identity card by NIOS. He appeared in the exam held in 2019, and initially the result was published, but subsequently withheld by the NIOS after noting that the appellant did not possess 45+% marks in the +2 examination, which was the minimum qualification required for teachers appointed in classes 6 to 8. Stop. The minimum qualification was a BA and a 2-year diploma in elementary education. Full stop. Paragraph. Noting that the appellant did not satisfy the eligibility criteria, the learned single judge has in the impugned order declined to grant the reliefs prayed for. Paragraph. Counsel to the appellant urged that the learned single judge had dealt with only one part of the prayer, namely regularizing the services of the appellant, and failed to address the other prayer for declaration of his result in the 2019 exam taken by him. This court is unable to agree with the above submission. The learned single judge does note the reason for withholding of the result of the 2019 exam, namely that the eligibility criteria was securing 45% mark in a class 12 examination, which the present appellant did not fulfill. Paragraph. It was then urged by learned counsel for the appellant that since the appellant had already got the BA degree, the above factor of not securing 45% marks in the class 12 exam should not be held against the appellant. Paragraph, the eligibility criteria is obtaining not just a BA degree, but also a 2-year, possessing a certificate of successful completion of a 2-year diploma in elementary education. Full stop. For that, the appellant had to necessarily have fulfilled the eligibility criteria of securing 45% in the +2 examination. Full stop. Without that, no mandamus could have been issued for declaration of his result in the said examination. Consequently, the court is unable to find any reasons for interfering with impugn or municipal judge. The writ appeal is dismissed.
Item note 35.
My lord, I may permit. I'll move a review application. Lordship, only I pray, my lord, I withdraw with the liberty to file
a review. All right. Consequently, the appellant seeks leave to withdraw the present writ appeal with liberty to file a review petition.
I only lead your lordship indulgence, my lord. I'll file a if delay that may be.
Delay will explain the pendency of the writ appeal.
That lordship, only one few words.
If an explanation offered in the application for condemnation of delay in filing the review petition, for the reason that the present for the if the pendency of the present writ appeal is offered as a reason for the delay in filing the review petition, it will be taken into account in accordance with law.
Well, most of it. I'll do it.
Item note 36.
Proceeding promotion during pendency of departmental proceeding. 11.5.
11th May. All right.
Item 37.
Had rehabilitation 30th
August.
Item note 38.
38 already decided the matter. That common judgment was under challenge.
Yep. The notice has to go.
Can dispose by that Joladhar Das in that common judgment.
All right. In view of the judgment dated, order dated 28/9/2022, writ appeal 1020/2022, the present writ appeal is disposed of in the same terms.
Right.
39.
May Lords. In this matter, my lord, I challenge there is annexure 1, the writ petition dismissed on 15B of Service Settlement Act, my lord. Only that ground that is not moved before the competent court, my lord. My case, my lordship, the revisional court has not given my opportunity. The matter regarding the document which are filed, that has not discussed at all. Only the basis of the petitioner in the revisional court that has been passed in his favor, my lord. I have given so document that is not distinguished at all. That has not discussed by the Honorable Single Judge, my lord. Only say that is 15B, so I cannot.
Sorry?
That is matter relating to 15B of Service Settlement Act. So you move before the competent court, my lord. Because my case is that which I have documents which are filed before the revisional authority has not been discussed at all in my case. Only the case of petitioner before the revisional authority, on basis of that document, order has been passed in his favor, my lord. Should have been given opportunity by remanding the matter at afresh, my lord. Your lordship kindly see that order of that is annexed for in writ application, my lord. Case 29 to 31, my lord. Order of the revisional authority, my lord. Nowhere discussed about the case of the opposite party in the revisional court, who is appellant before your lordship, my lord. That is page 30 of lordship, paragraph 2, my lord. But
Yes.
I mean,
Yes. Please read.
the learned advocate for the petitioner contends that Kabjuwari position note recorded in the remarks column against the specific plot in Arwar bearing so and so is erroneous as such. Recording in the remarks column leads to an equal division or partition of joint family property with one of the co-sharer, namely late Loknath Rao was transferred during his lifetime to his daughter and the Bhendi in RSD so and so dated so and so area of Etiki appertaining to CS plot number so and so, which is beyond his entitlement excess area so transfer with area 1.85.5 mile. Only the claim of the petitioner basis that has been allowed. Nowhere discuss about what document filed by the opposite party in the Tribunal Court that doesn't distinguish at all. Nowhere, only present. That must be vital document which are filed by the present appellant before the regional authority. That should be distinguished the document which are filed by the petitioner.
Notice.
The document is that I have annexed already read application annex 1, 2, 3.
Notice is accepted on behalf of respondent numbers 7 by Mr. Monty. Who will accept this is for the Joint Commissioner Settlement and Consolidation?
I can read.
Mr. Bhatia. Notice will now go to respondents 1 to 6 by registered speed post. Returnable on the next day. The tracking report will be placed in record. July.
Well, that is the interim application. They are already, Arwar will publish in their names. Maybe stay the impugned order.
No, what is happening because of the impugned order?
You will sell out the property in view of this order. All property you can sell away. So
this is an order passed in 22, sir. Notice on stay also. Right.
And nature of change, land should be changed in meantime. Always be.
In the meanwhile, status will be maintained. All right.
Obviously.
Item number 40.
The Lordship has posted similar matters to 49.
All right.
Yeah. Item 41. Item number 41.
All right. None of this.
Item number 42.
May I please, your lordship, my lord, in the limitation petition, notice has not gone. And my lord, here, the matter is that the opposite party was appointed in the Bhubaneswar municipality. Then it became Bhubaneswar Municipal Corporation from 2003. Well, that is, he was appointed on temporary basis as a tax collector. And my lord, against Section 73 of the Act, Section 73 says that without sanction and without approval of the government, there cannot be an appointment more than 6 months. And my lord, it has been subsequently amended. Now it is only 45 days. And that was also whatever the condition that was taken over by Section 117 of the Act. 117 and 19 of the Odisha Municipal Corporation Act. But here what has happened? But he was allowed to continue appointed as a tax collector. Then he was continued, and there was no approval by the government. Then subsequently, he was given appointment as a junior assistant. And then for revision of the scale of pay, while the matter was sent to the district audit officer of the local fund service, then it was objected saying that no, his appointment is not regularly done because that no approval has been obtained from the government. So that is why there cannot be any revision of pay. So far his post is holding as junior assistant. However, he is continuing as tax collector, let it be allowed for that. So against that, he came up before this honorable court. And this honorable court, following the order in another case, and that my lord, that is annexed to page 16, that order. Well, that order is also challenged in writ appeal number 1008 of 21. And my lord, I will make a distinction, your lordship will find
that Lordship kindly see page 4 of the writ petition. Just briefly, I have stated the distinction between the cases, two cases, because following that,
the single judge says the matter should be sorted out by the municipal corporation government without causing any hindrance to the petitioner. What does that mean?
that means, but that doesn't mean anything, my lord, because it must be within the parameter of law.
Correct.
My lord. So that is why, how can it be sorted out? Because the government says that you have given appointment that is temporarily. And my lord, section 73D says that any appointment made in this way is invalid in law. That is also said.
Delay. 383 days delay.
My lord, delay, my lord, the reason is that we could not work out in that order. That is why challenge, because at the government level, it could not be possible. So that is why the government could have also challenged. However, on their instruction, we are challenging it. But it will have a ramification in so many cases, because so many appointments are like that. And my lord, we have tried to sort out the matter, but it could not be possible.
Notice on both delay and appeal. Returnable. And the stay. There's no contempt petition filed.
Contempt, my lord, is not.
Then we'll just simply issue notice and stay. Returnable. 14th August.
Obliged. The next matter is same. My lord, may I draw lordship's attention on other three matters which can be brought on board and can be issued. Same matters.
Oh, there are several people like this.
Yes, other three matters, sir.
Oh, yes. Taken on board. Same order.
Greatly obliged.
Item 45.
My lord, only one correction is there. The opposite party number 2 is there, but it has not been numbered. Number to be written. 2. That should be 2.
You just say counsel for the appellate is permitted to replace the cost title with the correct numbering.
Only to number it.
Right.
Number.
Item 45.
Item 45, may I please your lordship.
Numbering
The challenge is made to the
parties.
Challenge is made to the order passed by honorable single judge at page 18 of the writ appeal. There, my lords, it's a case, my lords, it was earlier filed before the London Tribunal, and after abolition, it came to this court on transfer, my lords. And for the first time, it was listed before the honorable single judge on 24th of 8. And on the very day, my lords, the London Standing Council appearing for the School and Mass Education Department produced 2 numbers of judgments of the Honorable Supreme Court, and relying upon these, my lords, the Honorable Single Judge dismissed the petition. And my contention before the lordship that the decisions produced before the Honorable Single Judge and relied upon, that is completely different to the facts and circumstances of this case. I have also annexed that those 2 decisions, lordship may see at page 62 onwards, my lords.
What was your prayer in the petition?
Petition, my prayer was, my lords, to count particular period of.
So basically, you wanted the ad hoc period to be counted for regularization.
Yes, ad hoc period.
So these judgments don't talk about regularization by including ad hoc period.
My lords, that is in completely in different context, my lords.
No, what is the context?
As if, my lords, the order passed by Honorable Single Judge, relying upon these decisions, as if, my lords, the Honorable Supreme Court has blanketly said that ad hoc period will not be counted.
Let's see what the Supreme Court has said. Let's see the judgment.
Page 62, my lords. 62 honors, 2 numbers of judgments I have annexed, my lords. There, my lords, the ad hoc service, there was a rule of Uttar Pradesh regulation of ad hoc appointment, rules 1979, and the rule, it clearly stipulates that only after the selection process was the selection.
In your case, what is the relevant rule? In your case, what is the relevant rule, sir?
There is a, my lords, may see. There is no specific rule, my lords. There is no specific rule. There is no specific rule, my lords. Under the Puri municipality, my lords, the teachers are to be appointed in primary schools. There is no specific rule, my lords. Providing the modalities and the
If
criteria.
you want to be regularized in service, your appointment must be a regular appointment, correct?
Yes, my lord. What has happened, my lord? There was a selection committee that was constituted and selection process was initiated. The present applicant, my lords, participated in the selection process. She was selected, my lords, and her name also found place in the select list. But while giving appointment from the select list, my lords, some of the persons were given appointment. These also some of the persons selected, they were not given appointment. Subsequently, my lord, the ad hoc appointment was given to the petitioner and another from the said select list after the validity period of the select list, my lord. Thereafter, the correspondences went on. The petitioner represented that you have given appointment to others from the same select list, and my ad hoc service may be counted. So correspondence went on, and it went up to the government. Government said that you revalidate the select list, my lord. That is page 40 of Lord's mercy.
But how do these judgments not apply, sir? First, you have to show us these judgments do not apply.
My lord, these judgments, my lords, the judgments, my lords, of Lord's mercy. Page 62. The Lord's mercy, turn to page 40, my lords. Lord's facts will be clear. Page 40, my lords. The select list was revalidated, and the government said that you pass a resolution to the Puri municipality that you pass a resolution revalidating the select list. Accordingly, the resolution was passed, the select list was revalidated, and again proposal was sent to the government, but they did not they did not count my service period, ad hoc service period for regularization. The Lord's mercy, page 62, page 62. There is a rule, my lords. It stipulates a regulation of ad hoc appointment, determination of seniority. Service rendered by ad hoc appointee.
Where are you reading, sir?
Yes.
Where are you reading?
Page 62 for para M, Placito. Page 62.
But you have a similar rule for yourself.
No.
That's the whole problem, sir. Without a rule, how can regularization be ordered? By asking the ad hoc period to be counted.
There is a rule, my lords, and the rule clearly.
We saw there's a rule 6.1, which is for what purpose? We just now dictated.
What has happened in his case? A select list was prepared.
6.1 suppression.
A select list was prepared. Her name find place at serial number 20. So that the validity of select list expired on 18/10/1992. So she could not get appointment by that time. That select list there was no vacancy. After that,
vacancy.
what was our counter that I am saying? So thereafter, he made a prayer to give him our appointment on or DLR basis, whatever it may be. On considering her case, my prayer, municipality gave her appointment on 44 days basis. Thereafter, government directed to cause a fresh selection. And in the year 1990, we also can find it from page 56 of his writ appeal.
Yes.
May I read? Her name has been sponsored by the district of Puri. Her name was in the selected serial which was published on 18/10/1992. Although her name was in the selection list, in the meantime, selection list was invalid due to completion of 1 year on 17/10/1993. Then the applicant had requested to the chairman Puri municipality on 19/1/94 to give her appointment as a primary school teacher to manage her family. And she was appointed as a teacher for 44 days basis, so and so. Then, my lord, your page para 4, page 58. As for the instruction of the government in letter number so and so of the government department of school, the other 8 teachers are to face the selection committee affairs. If selected, then they will get their appointment. Consequently, Srimati Mishra, the applicant of OA, was selected for appointment as a primary on 4/1/1999. As per the government, it was stipulated the past service of candidates should not be considered. Accordingly, his signature has been counted from the date of her selection.
Page 40, may I draw your lordship's attention? Page 40. Page 40.
Even if that judgment should not have been applied, so he has no case.
Not applicable. No.
I am saying
page 40, your lordship. Page 40, your lordship. And have a glance, page 40, may I permitted to read my page 40. It was written by the government to the executive officer, Puri municipality, I am directed to invite reference to memo note so and so of the School and Mass Education Department on the above mentioned subject, and to say that it appears from your letter number so and so that out of 8 ad hoc primary school teachers, 2 teachers, namely Mamatanjali Mishra, the present appellant mailer, and Vishnupriya Narendra, were appointed on 4/3/1994 and 17/5/95 respectively by the Puri municipality after expiry of 1 year of time limit suggested by the selection committee. Besides, 6 teachers have been appointed on ad hoc basis from outside who had not come through the selection committee. The School and Mass Education Department may have no objection to accept the appointment of about 2 teachers who have come through the selection committee, where Inspector of School was also represented after the select list is formally revalidated by the Council. Since formalities have been observed in their case in order to regularize their services, appointment, and to avail of reimbursement of their salaries, etc., from the School and Mass Education Department, it is necessary to adopt a resolution in the Council revalidating the list up to the date of their absorption immediately, and proposal sent to the School and Mass Education Department under intimation to this department so that it can be taken up at the government level. As regards remaining 6 teachers, that is for others. Next page, you'll also see, according pursuant to the order of the government, page 41, my lords, page 41.
Yes.
A resolution was mailers, the Puri municipality, that was written by the executive officer to the government matters. In response to that, page 40 matters. Inviting reference to letter so and so, I am to say that 29 numbers of temporary primary school teachers appointed after 5989 by this municipality. Service of 21 numbers of such teachers have already been regularized in 2 phases by letter number so and so of your department. The service of 8 numbers of said teachers have yet to be regularized. In this connection, Puri municipality in its resolution number 8 dated 30th of April 97 have been pleased to revalidate the select list dated 18/10/92 till 17/5/1995 in order to regularize the services of Srimati Mamatanjali Mishra and Vishnupriya Narendra appointed beyond valid period.
Actually, the facts are to be discussed.
No, but that my lord, that page 60.
You did not file any reply anyway, right?
Yes, but that we should file a reply. It will also remind this matter that.
No, it was an OA which got transferred, or
yes,
that is an OA.
So in the OA, I think you filed a reply.
We have filed a counter, madam. The counter has not been discussed. That page 54 is our counter before the tribunal. You can find it.
All right, let's see that.
Page 54, annexure 3. And we have annexed the document. Why we have not regularized that annexure A by 5, page 60.
So only 2 were left out.
Page, said the page 61.
Only 5 years of service matters.
It is further decided the rest 8, not 2, 8. 8 ad hoc primary school teachers who are appointed without any selection committee and without the permission and approval of the H and the UD department are to face selection committee along with others for recruitment in view of this department resolution dated so and so afresh, and if selected, their past service should not be counted.
So they're placed on a different footing.
That is 3/3 of
these people are without a selection committee.
For this relates to 8. She's in the 8.
No.
Anyway, that matter has not been taken into account, the counter in that single.
But you seem to have annexed this Rashimani Mishra. Yes. Rashimani Mishra, even with your counter.
Mamatam.
No, the decision Rashimani Mishra.
Yes.
Yes, Madam. Rashimani Mishra, that principal ratio has been decided that ad hoc period will not be counted, but relying on a rule of that concern.
There's no rule here.
That there is no rule here. So you'll expect to decide whether that ad hoc period will be counted for the purpose of seniority. I can take instruction of
And this Anita decision is also peculiar to Maharashtra, right?
Yes, but that relating that, so far as their rule is concerned, taking into account that rule that has been decided, that cannot be taken into account.
So then we have to discuss the facts of the present
Yes.
case. You say the impugn order appears to have been passed by the learned single judge on the very first day, referring to two decisions cited by counsel for the respondent state, and holding that in view of the said decisions, open quotation, the ad hoc period will not be taken into consideration for calculating the benefits to the petitioner, unquote. Paragraph. The petitioner was claiming regularization of his service, of her service from the date of her initial appointment on ad hoc basis from 4th March 1994. Stop. The petition had been transferred from the Orissa Administrative Tribunal, bracket OAT, to the High Court upon its abolition, to the High Court. Full stop. Pleadings had already been completed in the said application at that time. Paragraph. Both the decisions referred to appear to have turned on the facts and circumstances of each of the cases. Full stop. In one case, there were rules concerning regularization of contractual employment, which did not permit inclusion of ad hoc service. Full stop. The other decision also did not pertain. You say one decision, bracket Rashimani Mishra was the state of Uttar Pradesh. 2021. 8 scale. 55. No, 558. Sorry, 558. Then turned on the rules. Then the second decision, State of Maharashtra versus Anita, concerned the posts of legal advisors, law officers, and law instructors in the state of Maharashtra, for which there were specific government resolutions. Stop. In the present case, admittedly, there are no rules as such regarding the issue at hand. Full stop. Consequently, it is not clear whether the aforementioned decisions had any direct application as far as the facts of the present case was concerned. Paragraph. Inasmuch as the impugn order does not discuss the pleadings in the case and the issue in light of the factual matrix, the court is unable to appreciate the reasons that weighed with the court does not have the benefit of the reasons of the learned single judge in rejecting the prayer of the appellant. Paragraph. For the aforementioned reasons, the impugn order is hereby set aside, and writ petition civil, bracket OA number 2200 of 2016 is restored to the file of the learned single judge in the roster bench, where it will be listed for hearing on 28th August. The learned single judge is, since the pleadings are already complete, the learned single judge is requested to proceed with the hearing of the writ petition on merits and endeavor to dispose it off as expeditiously as possible.
Item 46.
Item 46 and 47 not pressed.
Disposed of as not pressed.
Item 48.
48 is regarding regularization of DLR, my lord. Similar matter, lordship have kept to 25th of April.
25th April.
Item number 49.
49 is with regard rehabilitation assistance scheme, my lord. 38 of 2020.
30th August, right.
Item 50. Item number 50.
50. Item 50, without issuing notice, review order has been passed. And similar matter, notice has been issued and posted to 12th July.
Right, same order.
51.
And say list along with that.
Item number 51.
51 will also think similar to 13th April.
Here, what happened, there is about 240 days delay. That is also not covering the COVID period, and they have also not taken that point in the condemnation delay petition. And
what was the
apart from
date of the impugn order?
18th
18/2/2022, and they have filed the case on 11/10/2022. And your lordship, that is the COVID period is 23 2022, 28 to 2022.
120 days delay.
No.
16 count have na? No. It will start from
206
it will continue because once they have, since they would have filed on 29 to 2020, this is just, they have also not,
There's a whole batch, sir. This is not isolated.
Your lordship will find the condonation of delay petition, lordship,
page 27.
lordship have a glance. They have not taken that point. They have said the official delay in official procedure. So that cannot be a ground for condonation of delay. And that's why this is a case, my lord. This is, of course, even though it is for regulation, your lordship will find 2006 they were appointed, and the government has granted permission to appoint them, even though they have requisite qualification. But that AICT has not.
If you agree, we can send it back because it's first day, no counter, nothing.
No, it is not a first day.
Page 27.
Here, my lord, I didn't have, it is not a...
Identical matters are fixed to 13/4. Why are you objecting?
No, I am objecting because there is delay. You have not taken that point. This is a case, my lord. This is a case where the government has granted permission. If they have not,
I'll satisfy on that.
They have not enclosed the entire writ petition. So, my lord, I would have placed that because the government has granted permission for these persons to allow them for in one-time measure. And in basing on that, my lord, with effect from the year 2006, they were appointed. Now, my lord, this Honorable High Court has said that you take step to regularize their services, and that to 2019 will have no application here because they were appointed in the year 2006 as per the advertisement 2005, and that to government has granted permission to them. For one time, government has also said that you consider their case even though they have not passed from the AICT recognized institute and the candidates are not available, so you recruit them. That is the basing on that, my lord, these present opposite parties were appointed. It is not a case that they were appointed, rehearse the rule.
Yeah, Mr. Jena.
My lord.
In the writ petition, no counter was filed.
In the cover, in some cases they have filed the counter.
So in all those cases are coming on 13th April. If you want your case to go back separately, we can send your case back to the single judge if you so wish. Because in your case, no counter has been filed.
So, my lord, without
condoning order to be passed as was passed in those cases.
Without condoning the delay, my lord, place it on 13/4 so that I will.
That's all he's saying, sir. That is all he's saying. The 13th April. Right.
Item 52.
52, my lord, 14th September. Work sales.
All right, 14th September. Right.
Item 53.
53, 11th May, my lord, vigilance case promotion during pregnancy.
Item 54.
54, my lord, also that vigilance case promotion during pregnancy vigilance.
When is it coming up?
11th May.
11th. Okay.
11th May.
11th May. All right.
Item 55.
At 55 page 34 is the impugn order. That Honorable Single Judge has relied upon a similar order that's not covered by that judgment. That our case, he has manipulated certain documents and basing on his four documents. Lordship can find that.
Are you appearing in this, sir?
No, my lord, I am appearing in other case. No.
All right. There's no batch on this.
No batch.
Okay. Notice returnable. 10th July. There should be a stay of the impugn order. All right.
Item 56.
Lordship, kindly allow 1 week time. My senior is not well. Kirot Kumar.
All right. Counsel for the appellant stated to be unwell. List on. Second May, defects be removed in the meanwhile.
Item 57.
My lord, can it be taken some? I'm not feeling well some of the day, my lord. I'm not well.
Counsel for the appellant states that is unwell. List on third.
Item 58.
58 rehabilitation assistance case, my lord. Lordship has kept it 30th of August, my lord.
All right.
Item 59.
59 regulation 16th July.
Right, 16th July.
Item number 60.
60 that outsourcing 8th August.
8th August. All right.
Item 61.
Yes, my lord, though the petitioner is retired in the meantime, my lord, he's a person. There was a select list of the year 1997, but appointment was made in 2000. And a batch of cases were filed in the tribunal, similarly placed, which was allowed with the direction that their services shall be counted notionally from the date they could not give an appointment because of the official apathy. And that order was challenged that I have given it annexed to
service. How can the regularization date back to a point when you were not in?
No, not appointed. That service period for counted for the purpose of other benefits, retirement benefits.
How can it be? You were not.
That has been allowed, my lord. No, my case is valid. It has been allowed. And that order has been confirmed by this division bench of this honorable court. So I filed a representation to get a benefit of the similar nature. The writ petition was disposed of for disposal of my representation. Thereafter, no action was taken. I filed a contempt. And the contempt, when the honorable court has issued a notice, they wake up and rejected my claim on the plea that you have retired and you are also getting your pension from, because 2000 appointment also there as per the old principle, there to get the pension as per the old principle. This 3-year service benefit will not given it to me, it will of no avail. Against that order, I filed a writ application challenging that order. Now the writ petition is dismissed on the ground, it is a stale claim, you are coming late. That was not the ground at all by the opposite parties in the rejection order.
Even if it's not a stale claim, point remains that you're asking a period to be counted when you were not appointed at all.
Yes, that benefit has already been granted to the similar situated person.
There can't be.
And by this 3-year service, my lord, he may get some benefit, retirement benefit only.
There can't be negative equality on this, sir.
No, this is not a negative equality, my lord. This honorable court has upheld that order. These orders are there on record. Kindly have a glance.
Yes.
Division bench has confirmed that order also.
Right.
So now a coordinate bench of this honorable court passed some order and some persons have got the benefit.
Yes.
My lord, desperate submission is
in
this
good
person.
time. You did not come in good time. So
no, he has come in time. He has come in time. He has come to you, my lordship.
You retired when, sir? Let's see.
Retired in the a few days back. Just a minute. May 22, I think, my lord.
No. I think you retired in May 22.
Yes. At the time of filing this case, he was retired.
That's right. See, you were appointed on 18th February 2000.
Yes, madam.
You
He
made
was
your
59 years
representation.
now.
Yeah, you thought of approaching the High Court only in 2020. That's the delay that the judge is talking about.
That
20-year delay.
But my technically saying, my lord,
No,
I am
that's very.
but now,
very
my lord, his case was not at the initial stage. This honorable court has not dismissed his case. The only direction was given to representation. And had it been rejected on that ground, my lord, I have no case. But the rejection order that is at annexure 8, page 73.
Correct.
They have not taken that stand also. Now the honorable single judge has taken stand and dismissed my case.
Yes.
That is only my point.
All right. The challenge in the present writ appeal is to an order dated 12th August 2022, passed by the learned single judge, dismissing the appellate's writ petition civil 12584 of 2022. The appellant was seeking directions to the opposite party state to fix his pay annual increments and consequential benefits in the post of assistant Karmi teacher, is it? In the post of Sikhya Karmis from 1997 onwards. Paragraph. This was the second round of litigation before the learned single judge. Earlier, the petitioner filed writ petition civil number 34795 of 2020, which was disposed of by the single judge on 11 January 2025, permitting the appellant to make a representation to the opposite parties. Paragraph. The second writ petition was filed after the said representation was rejected by the opposite parties by the order dated 2nd May 2022. Paragraph. The appellant had applied for the post of primary school teacher in 1997, but was not permitted to be considered because of his age. After orders passed by this court in OJC number 10180 of 1997, his case was considered and he was appointed in the upper grade school in Tirto on 18th February 2000. Claiming that others in the batch had been impaneled in 1997 itself. He filed the writ petition before the High Court in 2020, claiming parity with those teachers who had approached the Orissa Administrative Tribunal, bracket OAT, in 2008 itself. Stop. The ground on which his plea has been rejected is that he was appointed only in the year 2000, and therefore his benefits could not be computed on the basis that he was appointed in 1997. Full stop. His case was therefore distinguished from the others who had joined service in 1997 itself. Paragraph. Having heard learned counsel for the appellant and having examined the impugned judgment of the learned single judge, the court is unable to be persuaded to interfere. Full stop. If indeed the petitioner was not even in service between 1997 and 2000, he cannot expect that period to be counted for the purposes of fixation of pay, or for that matter, even his retirement benefits. No grounds are made out for interference. The writ appeal is dismissed.
Item number 62.
Yes, please.
62 mal 30th August. Rehabilitation.
No,
62, sir.
This is LIC.
Sorry. Sorry, sir.
Yes, sir.
Lord, may I please, my lords?
Yes.
Lord, the order, the judgment passed by the Honorable Single Judge under challenge, that is under Annexure 3. My lord, the facts are, the deceased policyholder took 3 policies on 14th of April 2004, and he died on 30th of July 2005.
All right.
So the death claim was lodged by the nominee, who is the respondent here of petitioner before the Honorable Court below.
Right.
And the death claim was rejected on the ground that the policyholder did not disclose about the previous policies. And your lordships may kindly see the repudiation letter is under at running page 22. With reference to the claim under the above policy on the life of your deceased nephew, and we have to inform you that you have decided to repudiate all the liability under the above policy on account of the deceased having withheld material information regarding his previous policies at the time of effecting the
No, but this
assurance.
repudiation of the policy happened beyond 3 years.
But that is also not correct, my lord, because here the policy comments on the April 2004.
Correct.
And it died in July 2005. So
Right.
just 1 year after the policy he expired. So the claim arose within 2 years from the under the old act. Policy can be called in question if the death or otherwise it is happened within a period of 2 years. But after the amending act of 2015, that says.
Where is the amending act?
Yes, my lord.
Have you set out the provisions?
The Honorable Single Judge has referred to the amending act of 2015, wherein it was said that policy cannot be questioned on any ground after the expiry of 3 years. But here the policy commenced on April 2004 and the deceased died in July 2030. So the death claim arose within a period of even 2 years. So under the old law, my lord, we
Where
could
is
have.
that old law, sir?
Yes, my lord.
Show us the provision.
Insurance Act 1938. Section 45.
Yes.
Under the old section 45, prior to the amendment was, policy cannot be called in question on ground of misstatement after 2 years. No policy of the life insurance effected before the commencement of this act shall after the expiry of 2 years from the date of commencement of this act, and no policy life assured effecting after the coming into force of this act shall after the expiry of 2 years from the date of which it was effected be called in question by an insurer on the ground that the statement made in the proposal for insurance.
So even under the old law,
but yes,
the repudiation had to happen within 2 years
yes,
from the date it was effected.
Yes.
So it became effective from the date the policy started, which is 14th April 2004.
Policy started with on 14th of April and the life assured expired on July 2005. So before 2 years of the expiry of the policy, the death claim was lodged.
So
yes.
No, you are the one who's repudiating it.
Yes, my lord.
Your repudiation happened in 2008, sir.
We can call in question if there are any misstatement in the policy. We can call it question within a period of 2 years.
Correct.
And now the death happened in 2005. Thereafter, the claim was lost, and we have repudiated.
You can't repudiate beyond 2 years. That's what the law says. You repudiated in 2008.
But the cause of action has
If you take the death to be the cause of action,
yes, my lord.
This repudiation is beyond 2 years after the death.
But the policy
death happened on 30th July 2005.
But the policy has commenced on 14th of April, and the death commenced. So
you're omitting all the years,
yes,
which is why you're having a problem. When you specify a date, please give us the year of the
the policy date of commencement of the policy is 14th of April 2004.
All right.
And the deceased life assured expired on 30th of July 2005.
So you add 2 years either from the first date or the second date. When does the 2-year period come to an end?
2 years period, if the death has happened within that, we can call in question because the claim was immediately
It doesn't
lost.
say that, sir. Just read section 45. Section 45. No policy of life insurance.
Yes. Shall we call it
effected after the coming into force of this act shall, after the expiry of 2 years from the date on which it was effected,
yes,
be called in question by insurer.
My lord, here the cause of action for the claim arose within the period of 2 years from the date of commencement of the policy. So we can very well question while processing whether...
No, when can you question? Any time which you choose, you can question.
No, we repudiated the claim in 2008.
When should you, according to you, what was the outer limit within which you could repudiate? Now you have the old section 45. You forget the new section 45.
Sir.
Under the old section 45,
sir,
what was the outer date within which you could repudiate? According to you.
We could call in question. Suppose the policy would have run. Suppose the
Shall I ask you this question?
No, sir.
I'll ask you the question like this.
Sir.
Could you call into question this policy in the year 2015?
And even after the old act, even after expiry of 2 years or so, we could call the policy in question.
When? No time limit at all. You can call it in question even in 2030.
That is the law, my lord.
Which law? Show us the law.
Yes, my lord.
Show us the law. What is this? What are you showing us?
On the judgment of the Honorable Apex Court, this is the recent judgment of the Honorable Apex Court, wherein they have dealt with the case right from Mithulal till Asa Goel and subsequent judgments also. In the Mithulal case, my lord, the policy of the death occurred within a period of 2 years. But in the Asa Goel case, the death occurred after the expiry of 2 years. Even there also, their lordships have said that yes, even after the 2 years also, the insurer can call the policy in question if it was found that any statement made at the time of taking the proposal was deliberately false.
No, but this whole section 45 is because of false and inaccurate statement.
And specifically, my lord, this judgment will help me because here also the policyholder expired within a period of 2 years. But the claim was repudiated later on. And
what is that later on? I want to see what that later on was. Where is that later on? Let us see that.
On paragraph 5, my lord. On 22nd of September 2009, the appellant issued a policy of life insurance to the spouse of the respondent based on the disclosure contained in the proposal form. The respondent's spouse died on 8th of February 2010. On 20th of May 2011, nearly 15 months after the death of the respondent who was a nominee under the policy, issued the appellant submitted a claim of 10 lakhs. And on June 2011, the appellant sought copies of the medical report.
Sir, what are you saying? The repudiation was on 30th August 2011.
Yes, my lord.
The policy was issued on 22nd September 2009.
Yes.
How can you take benefit of this decision? The repudiation was within 2 years.
But there are judgments which have been referred to, my lord.
Certainly, this judgment does not help you, sir.
My lord, this
repudiation was within 2 years.
Your lordship may kindly see paragraph 26, my lord. Paragraph 26 onwards.
No, the whole section talks of false statement. You're missing the point, sir. Section 45 permits you to repudiate on these very grounds that the report of the medical officer or referee or friend of assurance or in any other document leading to the issuance of policy was inaccurate or false. This is the very ground on which you are permitted to repudiate under section 45.
Yes. Probably I am not in a position to clarify. The law is, my lord, any statement that is also quoted in the very judgment any fact which would influence the judgment of a prudent insurer in fixing the premium or determine whether he would like to accept the risk, any fact which goes to the root of the contract of the risk has a bearing on the risk involved could be material. And that would be till the
So the
claim.
whole of section 45
Sir.
is for these kind of contingencies.
Sir.
That a false statement is made or something is suppressed. It is for these contingencies that section 45 has been enacted.
My lord, my responsible submission of section 45, we could not have called the policy in question if you would have survived beyond 2 years. If you would have survived beyond 2
Sir,
years.
What are you saying? Why are you foreclosing your right to repudiate?
But
Even if he survived, it had nothing to do with the man surviving or not.
My lord, the claim will.
If you find a statement has been made falsely
Sir.
by suppressing material facts, and there's a further caveat, you have to show that it was on a material aspect.
Sir.
Suppressed facts which it was material to disclose.
Yes. And according to us.
No, this has to be done within 2 years. Irrespective of whether the person survives or not.
My responsible submission is when the case of repudiation comes, the repudiation comes when the claim is lost. Here the policy date of commencement was 14th of April and he succumbed to death on 30th of July.
You're forgetting the year. You're forgetting the year.
2005, my lord. 2005, my lord. And thereafter the cause of claim arose.
All right.
So he lost the claim. And we have repudiated it on 2008.
Which is well beyond 2 years. 2 years beyond the date of the policy. 2 years beyond the date of the death.
My responsible submission is if the policy would have run beyond 2 years under the old act or beyond 3 years under the new act, even if you would have suppressed something, we could not have called in question. But in the particular case, when the policyholder died within a period of less than 2 years from the date of commencement policy, we can very well inquire into the matter and we found that
this judgment doesn't help this kind of a proposition which you're advancing. Is there any judgment which helps the proposition you're advancing that at any time you like, you can repudiate, irrespective of when you're repudiating? When I asked you, can you repudiate after 20 years? When I asked you if you can repudiate after 15 years, after 20 years, you said yes, correct?
Pardon?
I asked you a question, can you repudiate after 15 years? No. After 20 years?
No, repudiation comes when a claim is made.
Suppose I'm asking you, sir, the section says...
No, it could not be...
The section says when the policy is effected,
yes.
Right? Not when a claim is made.
No matter. When policy claim, when the claim will be made, either on the death of death
sir,
or maturity.
The language of the section is...
My lord, the claim will arise either of the
so the language of the section is not when the claim is made. The language of the section is when the policy is effected.
My lord, may I explain, my lord? So far in insurance policy is concerned, the policyholder, if the policy has run the period for which the policy is taken, he will get the entire amount. If after submitting the proposal and paying the premium, the policy has run beyond 2 years, we cannot call in question on any suppression of fact. Under the old law and under the new law, after 3 years, we cannot. Even if he has suppressed something, we cannot. The claim will arise, my lord, after the death, in this case, after the death. Not that we can call the question after the expiry of the maturity period. We cannot. If the policy has run this maturity period, then we are bound to settle it. Even
so you're basically rewriting section 45 to suit your own convenience.
No, my lord.
You don't want to go by 45 because 45 doesn't talk of anything that you're saying.
My lord, probably I am not in a position to convince. Your lordship has fixed another matter to 2nd of May. Your lordship may kindly adjourn it. I will.
Which is the other matter? Which other matter?
Another matter was then last week, your lordship fixed it. Similar matter. In respect to the very life issue.
You don't have the number, you don't have the case details, nothing.
I'm giving.
Do you have a copy of the order passed by us?
I'm just passing on the number.
Or it would
2nd of May.
After lunch we cut.
I could not arrive, reach in the first hour. There are two wreath appeals. I had mentioned before Lordship in last Thursday, and your Lordship has directed that it will be listed on Monday, but it is not listed. Maybe listed tomorrow because contempt is there.
Okay, give us the numbers.
That I have given.
Tomorrow.
Press admission.
Right.
Item 62, sir.
Which is the matter?
One matter is OLR, whether permission is required.
No.
Oh, sorry. I'm sorry.
In that case, also the deceased life was the same person, because those policies were
Just
taken.
simply say list on 2nd May, along with the appeal. 1, 4, 3. All right.
Okay.
See, you must come prepared with clear list of dates, provisions. I'm
Sir.
sorry to say, I mean, we expect far better assistance. Yes.
Item 63.
The order of the Honorable Single Judge is assent before your Lordship. My Lord, here, the Honorable Single Judge has dismissed my writ application, though I am covered by your Lordship's judgment in Narottam Ratha case. Your Lordship may kindly turn to Annexure 7 of the writ petition. Here, your Lordship will see at page 36 of the writ petition. Second,
This was dismissed on the first day.
yes, ma'am. My Lord, here the ASO has said that in the second settlement operation, if the lease is found to be genuine, it will be recorded in your name. My Lord, he has to make an inquiry. As per Narottam Ratha's case, your Lordship has granted two things that ASO cannot do. Secondly, if ASO also does, then here the lease, if the lease is in question, that will be decided by the government in appropriate proceeding. There is no proceeding against me, my Lord. Can the ASO override the lease case, my Lord?
My Lord, the impugned order reveals that he has not filed any document before the Honorable Single Judge. Firstly. Secondly, so far as the applicability of the Narottam Ratha case is concerned, that is the usual submission made by the petitioners. Let them appear before the Single Judge. So because it has to be examined, whether because we have not filed our counter affidavit before the Honorable Single Judge. He has only
What date was Narottam Ratha decided?
that is 2nd January.
2nd January.
That is prior to this order.
Oh, you say it is submitted that the impugned order was passed on the very first day of hearing of the writ petition on 11 January 2023. But was it brought to the notice of the Single Judge? Narottam?
My Lord, it was given. It was given.
Narottam Ratha judgment?
Yes.
That is not reflected.
No, Narottam Ratha could not have been because your Lordship passed in 2023.
Yeah.
This is also 23.
Yes, 23, your Lordship delivered the judgment on
4th January.
4th January. This was
is
on
on
11th January. It was brought to the knowledge that there is a division bench judgment guiding the field.
Okay.
It was, but it is not reflected. If it is.
All right. It is submitted that although it was brought to the notice of the learned Single Judge, that the division bench had passed an order in Narottam Ratha versus.
My Lord, WPC number 1608 of 14 and batch of cases.
Dated?
My Lord, dated is
4th January.
Yes, my Lord.
This is not reported. What is it?
2nd January 23.
This is still not reported.
Well, but it is available in the net.
No. It is one thing, sir. Just.
But it has to be reported.
Your Lordship has made AFR also.
I know. The impugned order was passed without taking this fact into account. Paragraph. The impugned order is accordingly hereby set aside, and writ petition civil 4670/2014 is restored to the file of the learned Single Judge in the roster bench, where it will be listed for hearing on 3rd July 2023.
My Lord, may say that the Honorable Single Judge will decide the applicability of the Narottam Ratha.
No, you can file a reply in that.
Okay.
the state, the respondent state will file its reply, Paravis reply to the writ petition positively by 27 June 2023, and the rejoinder thereto, if any, be filed by 3rd July 2023. No further time will be granted to either party for that purpose. The learned single judge is requested to proceed with the hearing of the writ petition merits and endeavor to dispose it of as expeditious as possible.
My lord, may I make one prayer?
Yes.
My lord, this is WA 207. Same order. In 206, I have also filed. That has not come. Same order, same judgment.
All right. Taken on board and same order. Right.
206 of 23, WA.
Right.
Grateful, Your Lordship.
Item 64.
64 my rehabilitation 30th August.
30th August.
Item 65.
65 also same rehabilitation 30th August.
Item number 66.
66 old pension will 25th April.
25th April.
Item number 67.
This is job contract 14th September.
Item 68.
68 14th September.
Item number 69.
Also 14th September.
Item number 70.
My lord, I pray 1 week time.
List on second defects be cured in the window.
Item 71.
71 will 14th September.
Item 72.
72 matter rehabilitation assistant matter relating to rehabilitation assistance scheme matter has been, similar matters have been
30th
posted
August.
to 30 August.
30 August. Notice and all that usual thing.
Item 73.
14th September.
74.
74 regularization, that is 16th July, madam.
Or
16th July, Sunday.
11th July must be, sir.
11th July.
11th July.
Sorry. 11th.
Item 75.
75 rehabilitation 30th August.
30th August.
Item 76.
Item number 76, my lord, on behalf of Mr. A. Patnaik, I pray for an adjournment.
Why?
Well, the conducting council is not well, my lord.
Can't hear you, sir.
The conducting council is not well, that's.
Counsel for the appellant is stated to be unwell. List on. April.
Item 77.
77 matter regularization to the post of service provider employees matter. Similar matters have been posted to 8/8/2023 matter.
This is outsourcing, is it?
Outsourcing.
Notice and same 8/8.
Item 78.
78 14th September.
Item 79.
79 may pray 1 week after why that a similar case has been decided, that is on W 731 of 2021. That order has not been uploaded. If that will be covered by the judgment, I can say.
What date is the order?
The 30th. It has shown on 28th March.
28th March.
By Justice
Talapatra and Justice Rathore.
Oh, okay. At the request of answer the appellant, let's on 18th April.
Item number 80.
My lord, in item
The counter has not been filed.
my lord, I have received the Parawai's comment. It is with me. Only 1 week. Next Thursday, Wednesday, I will file the lordship. Next Wednesday. The Tahsildar is only to sign the.
It is a matter, my lord. State government has to file a counter because, my lord, it has become an inter-district disputes because the petitioners, those who are living on fishing.
And more or less, my lord, it is connected with that same area, that PIL.
No, same area, that is for Chilika.
That is Chilika, but it is also.
This is river meeting to the Chilika.
Same.
For that, it is not. If your lordship cover that, it can be. It can solve the problem. Your lordship
It is
also
also
the prayer. We have said Because, my lord, lordship kindly for a moment. But this river was going in the particular area, they were fishing for time immemorial from their ancestor time. And they were living on that. But what happened from 94, the district were reorganized. These people are now in the village of Puri district. And the Puri district, after bifurcation, that area has gone to Khorda district. So what the Khorda administration saying, will not listen to you. This source will be given to our people of, that means they have made it Bharat and Pakistan.
My lord,
in a
not
country,
like that.
in a
My lord,
country and in a
may I pray one thing?
So that is the
this
only
may be
state
that
government
with
can resolve
that PIL 15th May, my learned friend, it will be convenient for all because the subject matter is same. Maybe the inter-district, in that also, that 4 district collectors are involved.
Lots of notice, while the matter is pending also, we are seeking direction to the government of Orissa Revenue Department. And also we have made a representation to them also. So if your lordship, and also, we have cited your lordship order.
Positively by 1st May.
15th May,
1st May you file the affidavit.
Oh, and maybe listed on 15th.
That to be filed before the next date, 15th May, along with
that PIL number.
PL number 746917.
Okay, 7469 of 17.
7469 of 2017 posted to 15th May. Item number 81.
May please your lordship, this is a matter, PIL matter, my lord. Matter relates to Sishu Bhavan, my lord. This matter appears to the release as per order number 39, my lord, dated 20th February 2023, my lord. On the said that this honorable court has directed to file compliance to the order dated 19th July, my lord. Meanwhile, 8 months has already lapsed. No reply has been filed. Day by day, my submission before your lordship that day by day it is deteriorating. The main problem now in Sishu Bhavan is that the life and property is in danger, my lord. There is no fair safety arrangement in Sishu Bhavan. As your lordship knows, ACB also has not made any arrangement, fair safety arrangement. The Sishu Bhavan is also not made any safety arrangement. So the life and property is in danger, my lord. And instead of developing, if the life and property will be in danger, what will happen, my lord?
My lord, on the committee constituted by your lordship, when he visited in November 2021, and the site in charge as well as the manager, engineer, stated that before the committee, that within 3 months they hand over the building. But now till today, they have not hand over. In November 2021, when the committee visited, they stated before the committee, in presence of the superintendent Sishu Bhavan, my lord. And
yes, Mr. Monti,
that compliance affidavit ought to have been filed, my lord. It is not filed. We have sent letters. Any short date may be fixed as a last chance. Peremptorily, we will file. Comply.
8 months have already been last, my lord.
That is true. That is true. I acknowledge that.
Order number 39, lordship kindly.
Yes.
Time is granted to the learned additional government advocate to file affidavit in compliance with the order dated 19 July 2022 on or before 1st May.
1st May.
List on 8th May.
My lord,
8th May.
My lord, subject to payment.
My lord, in WPC number 9504.
8 months. It's already consumed, my lord. It's a very serious matter.
My lord,
PIL petitioner, what cost will pay? This is not adversary litigation. This is not adversary litigation. You are appearing for the general public. Then you are interested to take cost.
General public will suffer.
All right.
Then what will happen?
My lord, my lord, the next matter 9504, my lord.
Yes.
A serious matter has been mentioned in this writ petition, and the counter does not speak about it. They are not disputed the fact, my lord. In one bed, there are 4 or 5 patients sharing the bed, which is strictly against hygiene. Hygiene is completely deteriorated.
We'll take it up.
In one bed.
Item number 82.
My learned friend has filed an affidavit. Just the copy has been served just yesterday night, Lord, upon me.
The
So I'll go through
affidavit
that
has been filed, my lords. It is dated 31st.
But Manoj, there were some mistakes to be corrected. It is filed yesterday. And copy has been served on my learned friend.
Just yesterday night they have served.
Our stand is that Manoj, it's already pending. Besides the other points on merits, it's already pending before the Public Accounts Committee for examination. It's being examined.
The Public Accounts Committee since last 12 years.
No.
Yes. But I will file a reply to that.
Which is this affidavit that has been filed? What's the date of the affidavit?
31st is the date. It was filed yesterday.
All right. The affidavit of the
Document say dated
department.
31st 3.
GA department.
GA department.
Dated 31st March 2023 be brought on record.
Along with an additional affidavit of the same date.
And an additional affidavit of the same date be filed, be brought on record. Counsel for the petitioner states that he would like to respond to the said affidavits.
Copies of the affidavits may also be served on us.
My trial in course of it.
It should be needed.
But we have also not received the copy of the affidavit.
26 June. 26 June.
Great.
Great. Mr. Gandhi.
Lordship, in course of the day. So, copy on this.
Item number 83.
83, my lord. We have filed an affidavit on 4th April.
It come on record. 4th April would not have come on record. All right. The affidavit stated to have been filed on 4th April 2023. Be brought on record. (27 June). There's a PL. No, 27th is already there. Somewhere. 12 July.
12
July.
Obliged.
Item number 84.
84. May This is a my lord PAL. Lord, the prayer, my lord, the petitioner to include boxing as a discipline, my lord, the sports. And my lord, since it was not included, this present PAL was filed, my lord. Lordship, on last occasion.
Costs have been asked to be paid.
No, we have filed the affidavit, my lord.
When?
Yes, that is our time.
Whether we get time or not.
29th March. Reply affidavit filed by
Not got a copy.
Sanatan Sahu, officer on special duty, Office of Sports and Youth Services Department.
We have received the copy.
You have received?
Yes.
Yes, yes.
What do they say?
They say, my lord, the apathy is writ large, my lord. On their affidavit, they're saying if that even though the seats have increased, but since 2014, my lord, there is no material that they have any issued a notification to include this present, my lord, boxing as a discipline. Lordship, see their affidavit, reply affidavit, para 2, space 2, that says, my lord, that I'm reading those for the response, my lord, para page 2, my lord. There is boxing as a discipline was considered for the admission in the sports hostel that functions under the administrative control of the Sports and Youth Service Department of the Government of Odisha. But the response was never encouraging, despite the fact that total number of hostel seats was 1010 on 1/5/2016 and the government increased it 1/2/50 with effect 1/4/2017, the response for boxing was far from satisfactory, my lord. Here, my lord, after 2014, my lord.
And after page 3, it becomes 4 and 5 are missing. I don't know because there's scan copy. So this list you're evaluating now. Hello. That's what in para 5 you say.
Yes.
Since the petitioner has provided a list of talents in boxing, the department is taking necessary steps to evaluate the talent. That's what you say.
Which boxing was one of the discipline out of the
Up to para 5, sir.
Yes.
Yes.
In reply to that, it is humbly submitted that abandonment of the petitioner's discipline, the petitioner had not recommended any talent to sports and youth service department to be scouted and sports hospital since inception of the case. However, since the petitioner has provided a list of talents in boxing now, the department is taking necessary steps to evaluate the talents of the entry in the sports. Yes. In view
What
of
is what
this,
petitioner, my lord, recommend? It is the government who is to uplift the sports, my lord. So now they since 2014, they are not taking any interest for this, my lord, game.
After they're saying we were going to evaluate, you're still saying they're not taking interest.
Lordship only after your lordship's intervention.
No, so you want it or you don't want it?
Yeah, I want, my lord. Definitely.
If you don't want, we can close the matter. If you want, we'll ask them to tell us after evaluating these boys what the decision is. What do you say?
Lordship, in the interest of boxing, lordship will pass an order.
An affidavit has been filed. By the on behalf of the Sports and Youth Services Department, stating inter alia that open quotation, since the petitioner has provided a list of talents in boxing now, the department is taking necessary steps to evaluate the talents for their for the entry in the sports hostel as per government guidelines. Unquote. It is further stated that open quotation, like other sports in the state, the government funds for advanced coaching in and abroad and international participants in various competitions must be, if the talent deserves it, unquote. A direction is issued to the department to place before the court by way of an additional affidavit the result of the evaluation of the persons whose names have been provided by the petitioner as evincing an interest in pursuing boxing as a sport. Full stop. The affidavit be filed at least 1 week prior to the next date. List on the PI list. The PI. 12th July.
So blessed.
Right.
Item number 85.
For the petitioner, Your Lordship.
For
Lordship,
166 of the Motor Vehicles Act.
Yeah,
Lord, this is a petition. I am appearing for the intervener, a bank, sorry, an insurance company. The Motor Vehicle Act has been amended and a period of 6 months of limitation has been prescribed. So there are twofold prayers. One, declare it ultra virus, and second is make it prospective. I was seeing the union counter says it's prospective. So the other one, your lordships have to decide. I think nobody is here for the union.
Lordship, I am appearing in virtual mode for the union.
Lordship, copy of the intervention may be served on us. We don't have.
You just filed it in court, we'll serve a copy on her.
Is it on board today?
No, Miller. Just, I'm so sorry, Miller. Just fine.
All right. It is stated that an intervention application has been filed by the
by the insurance company, Universal Sompo General Insurance Company. I'll give the cost.
All right, by the Universal Sanco.
And it is registered as IA 4973 of 23. IA
4973 of 2023. This copies of this said IA be provided to counsel with the other parties. The stand taken in the affidavits of the Union of India is that the amendment, section 166 back to 3.
Where is the counter?
Page 77 of the count. Running page 77?
Yeah, Motor Vehicles Act 1988 is only prospective in nature. For stopping that view of the matter, the one of the prayers in the writ petition does not survive. What is the prayer? Just come to page 21.
Miller, I've seen that. Your lordship sees page 23, Miller. That's where the prayer is.
23.
Yes. They actually don't, they leave out the expression ultravirus.
Ultravirus, exactly.
Correct.
Yes, sir.
Although it's there in that ground L. Does it satisfy your prayer, or you still want the section to be struck down?
I want the section to be struck off, your lordship. Let it come, your lordship.
All right. List on. July.
Lordship, please.
Oh, please.
Deeply please.
At number 86.
My lord.
Fresh affidavit has been filed.
My lord, yes. In pursuance of the order of this honorable court, we have filed the affidavit. My lord, there was a order that the chief secretary will file, but the chief secretary is in abroad, so the additional chief secretary, Revenue and Disaster Management Department, has filed this on his behalf. Yes, it is.
Can you just hand over a copy?
Yes, I'm sending the hard copies.
An affidavit dated 4th April 2023 has been filed. Stating that in the last 3 months, an additional 8 religious structures. The action has been taken in respect of 8 additional religious structures, out of which 4 have been removed, 3 have been relocated, and 1 has been regularized. The action with respect to the balance 5260 religious structures is stated to be in progress. It's amazing. The maximum is in Ganjam,
Yes, madam.
5679.
Yes, madam. The maximum is in Ganjam district.
The statistics provided in Annexure A to this affidavit reflects the position district-wise. Full stop. Ganjam alone has 5679 unauthorized constructions, of which 5531 have been regularized and 49 have been removed and 99 have been relocated. Bargad also is a large number. There are 947 in Bargad district, of which 548 have been regularized, 87 removed, and none relocated. In Cuttack, there are 906 unauthorized constructions, of which 396 have been regularized, 104 have been removed, and 73 relocated. A further update status report in the form of an affidavit we filed before the next date. July 13.
May I please, Your Lordship? Your Lordship, on last occasion, Your Lordship has directed opposite party 1 and 8 to file counter affidavit. 1 and 5, apologies.
I have sought for instruction only 2 weeks, madam. I'll file the counter.
Counsel appearing for opposite parties 1 and 5 seeks and is granted 4 weeks to file a reply. What about the others?
No, none of them. Only opposite party number 2 has filed counter affidavit. State has filed counter.
The other parties, the other opposite parties who have not yet filed any reply will also file the replies as a last chance within 4 weeks. Rejoinder for the next date. This one. 24th July.
Deeply obliged.
Item number 88.
88, I have to file the counter affidavit. The Lordship may grant me last chance to file a counter.
May I please, Your Lordship? I'm appearing for OP5, Your Lordship. I have filed my counter affidavit.
OP number 5 has filed.
They have filed counter affidavit, and on 29th March, they have filed an additional affidavit, my lord. I have to file that rejoinder, my lord.
Your Lordship, I have filed an IA also. My humble prayer before Your Lordship, I have already deposited 2 crores 39 lakh. Sorry, 2 crore 23 lakhs 39,393 rupees, Your Lordship, because I have been declared as the successful bidder, and this is not for the first time. Twice there was litigation against me by a particular person who has been named by the petitioner as the first highest bidder, whereas he is not the highest bidder. I qualified everything. His bid has been cancelled because he was unable to give the IT return as well as the bank guarantee. But whereas I have given
I will take instruction on all these things and I will file a comprehensive affidavit, madam, on behalf of the collector.
Start or rain, then I will not be able to extract the sand as per the tender, Your Lordship. And beside that, I have I have filed the appeal also, Your Lordship. Appeal which was against me by one R.J. Bharat Kumar, who has been named as the first highest bidder by the petitioner. Your Lordship may kindly see at page 35 of this appeal, Your Lordship, why the bid of this R.J. Bharat Kumar has been cancelled, Your Lordship.
That's right. Neither submitted IT return nor all right.
Your Lordship, my humble prayer, if there will be rain or flood, then I will not be able to extract the sand, and I have already deposited a huge amount.
My lord, your lordship has directed not to execute the lease deed. I think lease deed has not been executed. What's he saying? I don't know. I have to get instruction from the Tahsildar.
Lease deed has not been executed, my lord.
So how he is saying all these things?
A reply and additional affidavit has been filed by opposite party number 5, who is the successful bidder for the sand Sairat in question. Counsel for the state, Leonard, additional government advocate for the state, submits that a comprehensive reply will be filed by 3rd May 2023. Rejoinder to the affidavits be filed before the next date. List on.
I pray a sorted maybe.
Yes. 9th May.
My lord, some more time because the
next 3rd week of May. Because
why?
I have to get the. Oh, it's all right.
1st May you have to file an affidavit. 3rd May you have to file an affidavit.
9th May.
9th May.
It's okay.
89.
There is an interim order, my lord, that may be.
Yeah, interim order.
It is 89 appearing through DC.
Yes.
Lord, here with the leave application at flag A, I have filed this writ appeal. The impugned order is at page 94. Lord, the short point for consideration would be in the same name, both the parties, private parties, are at loggerhead for opening of a school. Now that our school is already permitted since 96-97, and since 2012 we have been receiving grant from the government. And accordingly, we are now running the school with government's grant and it's a regular institution. The respondent's institution, Lord, has been combating for the purpose of a retrospective permission. If you see page 95, the honorable single judge, where I without including me a party, without giving us opportunity of hearing, directed that their appeal, which was allowed in the year 2000, that their application, that permission will be relegated back to the year of their application. That is at page 95. But in fact, if this is done, Lord, I have no problem. But only thing is that this should not affect my status as I added school. That's my concern. Page 95, Lordship. Yes. Here I was not implemented as a party. But only my concern is this observation of the honorable single judge should not affect my status as a added institution. Otherwise, Lord, it will affect me.
All right. The grievance in the present petition.
In the meantime, that has been implemented. I have filed a counter, Your Lordship.
Oh, the impugned order has been implemented?
Yes. Your Lordship, my
without
counter,
affecting my status, that observation.
My counter is filed on 2nd February 2023.
Okay. The appellant whose writ petition was disposed of by the impugned order dated 20th March 2008 is aggrieved only to a limited extent that the permission to the extent that it has been observed therein that permission for establishing the school, open quotation, should relate back to the academic session 1993-94, unquote. No, has permission not been granted from 93, 94, Mr.
Yes.
Doctor?
In fact, they should have got, in fact, in terms of the appellate order, they should have got permission from 2000. But because of the observation given by the honorable single judge, it is now relegated back to the date of application, 93, 94. So if that is now taken into consideration, I am a school which is operating since 1991, and I have been receiving grant in it will be affected. That without affecting me, let that be. In the same village, same name. That's the interesting thing.
One school, two management.
No, not one school. Two school in the same name. Mr. Kotia kindly appreciate. Two school in the
So
same
the
name.
apprehension expressed by, you say not the appellant, you say apprehension expressed by respondent number 5. Is that the above observation that the permission to the appellant school, bracket, which incidentally has the same name as respondent number 5, bracket, would run from academic year 1993-94 should not affect the status of
The appellant school.
you are the appellant school or the respondent number 5 school?
But here I am the appellant. Before your lordship, I am the appellant. Respondent number 5 was the petitioner before the single.
Should not affect the appellant school, which goes by the same name as respondent number 5. Very good. Counsel for the state informs the court that the impugned order has in fact been implemented. So clearly the implementation is not affected the appellant school as if it had, the court would have been approached for directions. In that view of the matter, no further directions are called for as far as the present appeal is concerned. It is disposed.
Great.
Item number 90.
My lord, I pray for 1 week time only, my lord. I will file some documents. The appellant's husband is ill, my lord, for which he could not come, my lord. Yesterday I contacted the appellant, my lord. In this case, my lord, also, my lord, in portions to order dated 4/8/16, counter has not been filed, my lord. 4/8/2016, my lord.
But this is a writ appeal, so there's no question of counter.
I pray for only 1 week, my lord. Next week, any day.
Prays for one more opportunity to place and record documents to show that the appellant is a resident of Sargipalli 2,
my lord.
Anganwadi Center area. List on. July 19.
Interim order to continue.
Interim order to continue.
Supplementary list fresh admission item number 1, CRLMC 2187 of 2017. Item number 2.
My lord, item number 2 not press.
Not press dismissed.
Item number 3.
Item 3, your lordship, this matter may kindly be disposed of, granting liberty to the petitioner to raise all the
permitting the petitioner. All right.
Item number 4.
None appears dismissed.
Item number 5.
May be permitted to withdraw, your lordship.
Dismissed as withdrawn.
Published.
Item number 6.
None appears dismissed.
Item number 7.
None appears dismissed.
Item number 8.
May I please, your lordship? Lordship, challenging the order of cognizance made under section 420, 465, 468, 471 IPC. Order of cognizance is
permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed. All right.
Item number 9,
Same.
item number 10,
None appears dismissed.
item 11,
Yes, may I please, my lord, here, my lord, on the same set of allegation, my lord, once the GR case was instituted and pursuant to the filing of the FIR, my lord, the charge sheet was accordingly filed and also cognizance was taken in which my name does not find place. Thereafter, my lord, the same informant once again filed complaint case alleging therein that I am alleged under section 323. My lord, accordingly, my lord, that cognizance also has been taken. Once the same set of occurrence, 2 cognizance has been taken, my lord.
All right. So you can point it
Which
out.
is bad by 468 2, my lord.
You can point it out to the courts.
Pardon, my lord?
You can point it out to the trial courts at the appropriate stage, permitting the petitioner to raise all pleas at the appropriate stage. Petitioners.
item number 12,
Your Lordship, this case arises from a FIR and counter FIR, Your Lordship. And it's a pure civil dispute when in a single family, they are residing as ancestral property, they are inheriting an ancestral property, and the dispute has been raised, Your Lordship. And what has happened, Your Lordship, being a petitioner, we have challenging the FIR filed by them and the cognizance taken by the land magistrate. Similarly, also, they have filed a CRLMC petition, Your Lordship, which is pending before this honorable court and posted to 2nd May.
What's the number?
This is CRLMC number 1261 of 2017.
List along with 1261 of 2017 CRLMC on 2nd May.
Yes, Your Lordship.
All right.
item 13,
Pardon the mention, my lord. Item 7, my lord. No, non-appreciation. No instruction, my lord.
No instruction. 7.
Item 7.
item 13,
None appears dismissed.
item number 14,
Same order.
item 15,
Same order.
item number 16,
Same order.
item number 17,
Same order.
item number 18,
May I please, Your Lordship? Here is the case, my lord. The order at Annex 5 is under challenge, and this is out of a 138 proceeding, my lord. Here in this case, my lord, the petitioner has obtained the loan, hand loan from the opposite party, and thereafter, my lord, he liquidated paid all the amount in the 2014, my lord. By that time, he had handed over the check as a security. If I never pay the same, then that will be realized, my lord. After receiving all the amounts, he did not return that check, my lord. But later on, he used the said check and also inserted all the things in the check, saying that as if I have written all those things. I have categorically mentioned in my evidence, my lord. I kindly see to that extent I want to draw your attention. So far as in the page 11 of the cross-examination by the complainant, my lord. Page 11, my lord, at para 11, my lord. The accused himself gave me the check after filling the same. No one has seen this. My respect, then thereafter, in my cross-examination, I have categorically said, my lord, at page 16, my lord, I do not know English as I have passed 7th class, which in Hindi medium. So my respect to submission in the check, it has been mentioned English, but I know only Hindi. Then thereafter, I filed a petition by the Annex 3 saying that let it be referred to the handwriting expert to know whether the person who has filled up that check is correct by me or anybody else, my lord. Then thereafter, they filed objection. The trial court, by order by the Annex 5, my lord, rejected the same without referring to the handwriting expert. This is my submission before lordship. To that extent, keeping in with the decision of this honorable court, my lord, to that extent, my lord, that has been referred to the handwriting expert when there is a dispute with regard to the signature, my lord.
You can make that request to the trial court, sir.
Trial court, that has been rejected, my lord. That's why I have before your lordship, my lord. Keeping in with the decision of this honorable court, my lord.
So let's see the order.
Yes, my lord. That at page 22, my lord. Got it, my lord?
Yes.
Last paragraph. On careful scrutiny of evidence, as well as on going through the section 138 and 113 of an act, it came to light that the fact of taking money from the complainant by accused and issuance of a check against the said debt and also the signature appeared on the said check is of accused is well established. Now,
The case was ripe for judgment, sir, in 8/8/2019 itself.
That I am only in respect of the check which has been written by English. I am only know the Hindi. I have not written, but I am not disputing about my signature, my lord. Keeping in view the decision of this honorable court, my lord, that I refer to the handwriting expert to know that whether I have filled up the check, because I have categorical mention in my cross-examination to that extent. I want to lordship's attention, my lord, respect to submission before
The present petition is to
my
nominate
lord,
it.
at page 14, my lord, para 9, my lord, kindly see. With great respect to that extent, with your lordship's permission, my lord, that it is pertinent to mention here that I used to read and write only Hindi, as I do not know English or any other language. Therefore, I have signed the said check in Hindi only. But the body of the said check have been filled up in English, in other ink, and after manipulation of the same, the complainant has filed this case against me. At this juncture, keeping in view all these things, my lord, after when it was brought to the knowledge of the petitioner, my lord, after cross-examination, he has filed such a petition, my lord. So my respect to keeping with the decision of this honorable court that has to refer to the handwriting expert to know that who has filled up that check, my lord. So my respect to this is the decision of this honorable court. To that extent, I will.
The present petition is to order dated 2nd May 2019, passed by the JMFC Bar Bill, rejecting an application made by the present petitioner accused in 1cc case number 52 of 2017 to send the handwriting of both parties and the checks in question to a handwriting expert. Paragraph. Relying on the decision of this court in Messrs. Surbika Distributors Private Limited versus Messrs. SR Retail Zone Private Limited, 2018-70 OCR 51. It is ought to be contended that since the signature is in Hindi, signature, the accused purported signature on the check is in Hindi. It is essential for comparison of the handwriting. And this request ought not have been refused by the learned trial court. Paragraphs. The learned JMFC has an impugn order come to the conclusion that there was no ambiguity or doubt regarding the signature that warranted sending the signatures of the parties to an handwriting expert. The trial court is in the best position to assess the need for the request made by the petitioner. Urgent reasons appear to have been given for refusing the request. Paragraph. It is seen that the case was at a stage of pronouncement of judgment when the interim order was passed by this court on 8th August 2019. Full stop. It is only the pendency of the present petition and the interim order that is preventing the judgment from being pronounced. Paragraph. The court is not satisfied any grounds have been made out for interference. The petitions accordingly dismissed. The interim order is vacated. A copy of this order be sent forthwith to the concerned court.
Item 19.
Much obliged.
None appears dismissed.
Item number 20.
None appears dismissed.
Item 21.
None appears dismissed.
Item number 22.
May I please, my lord. In this case, the petitioner has filed for quashing of the entire criminal proceeding. Offences are under section 341, 323, 324, and 50634 IPC. Notice was issued to the informant. Matter has been amicably settled. Informant has entered his appearance.
Counsel for the respondent 2 confirms that the matters have been settled between the parties. That view of matter take appropriate clause and all proceedings consequent thereto hereby quashed. Obliged. Put down his appearance.
Item number 23.
None appears dismissed.
Item number 24.
May I please, Lord. Here, my lord. I have filed the evidence affidavit in chief before it is arising out of offense under section 138 of NA Act, my lord. I have filed my evidence and affidavit in chief, my lord. But due to the by lawyers' difficulties, I could not appear before the Royal Trial Court for my cross-examination. Therefore, the matter was posted for argument, my lord. Thereafter, I filed a petition for recall of the order and for my evidence, my lord. Royal Trial Court has rejected the same by running page 12, my lord, Annex 1, stating that I have no power to recall if it is you approach the competent court under section 482 of CRPC, my lord.
You say the challenge in the present petition is to an order dated 17 December 2018, passed by the learned JMFC Bhubaneswar in 1cc number 2557 of 2011, declining to recall its order dated 16th May 2018 and allow the accused to adduce evidence from the side of the defense. Paragraph, it is seen that by the order dated 16th May 2018, where is that order dated 16th May 2018?
But
Where is that order dated 16th May 2018?
My lord, it is 17/12/2018. That is the order filed.
Sir, kindly follow the question I'm asking you.
Sorry, my lord. Yes, I have not annexed that.
That is what you have to answer. That is the order you wanted recall of. You have not enclosed that order.
Recall 17. I'm sorry, my lord. I'm sorry.
There's no point, sir. The 4 years of pendency of the present petition, the order of which, copy of the order of which recall is being sought has not even been filed in this court. So there's also no, even today, the learned counsel for the petitioner is unable to produce the copy of that order. Stop considering that this is a matter of 2011, pending in the trial court for over 12 years. The court does not propose to grant any further intelligence in the matter.
My lord, I'm sorry, my lord. My lord, I beg apology, my lord. Here, my lord, I have filed a petition on 16/5/2018 for recall, my lord. That was my case was I was declined to give any evidence, my lord.
I don't know all that. We don't have the order at all.
Well, this is the order.
The interim order is vacated.
17/12/2018 order, my lord, I have quoted, my lord.
What have you quoted?
Annex 1, my lord.
Sir, you have quoted or you have enclosed that order?
I have given, my lord.
Which is the order I am asking for?
My lord, may I read, my lord?
Which is the order I am asking? I am asking you a question now.
It's not the 16th.
Which is the order that you are seeking recall of?
17/12/2018, my lord.
Which is the order you are seeking recall of? Which is the order of which you are seeking recall? Which is that order?
I'm sorry, my lord.
The interim order is vacated. The petition is dismissed. The copy of the order be sent immediately to the concerned court. Yes.
Item number 25.
None appears dismissed.
Item 26.
None of these dismissed.
Item 27.
None of these dismissed. Okay, memo taken on record. Infructuous. Dismissed.
Item 28.
Here I am seeking questioning of cognizance order, my lord. That this matter is amicably settled, my lord. And the complainant also filed a petition before the London court below to withdraw the case.
Then that's okay.
Yes,
It is stated that the complainant herself has filed a petition in the court below for withdrawal of the case, that matter no order needs to be passed in the present petition.
That will be considered, my lord. By the
That will be considered in accordance with law. The petition is disposed of, interim order is vacated. Yes.
Item 29.
Does the matter become infructuous?
Infructuous disposed.
Item number 30.
None appears dismissed.
Item 31.
Matter can be raised at the time of hearing, ma'am.
All right. Permitting the petitioner to raise all please.
Item 32.
None appears dismissed.
Item number 33.
No instruction.
No instructions dismissed.
Item number 34.
None appears dismissed.
Item 35. No more.
Dismisses withdraw.
Item number 36.
None appears dismissed.
Item number 37.
None appears dismissed.
Item number 38.
No instruction.
No instructions dismissed.
Item 39.
None appears dismissed.
Item number 40.
Both matters, none appears dismissed.
Item 41.
Same one.
Item 42.
Same one.
Item number 43.
Permitted to raise.
Permitting the petitioner to raise all please.
Item number 44.
None appears dismissed.
Item 45.
May I please your lordships? The petitioner in this sharelemship matter challenged the order of cognizance dated 24/8/2004, my lord, in 1cc number 76 of 2004 for the offences 420 and 34 of IPC, my lord. Present petitioner is only witness to this the agreement, that is partnership deed. My lord, kindly have a glance, that is page 25.
Yes. You can raise all these pleas, sir, at the appropriate stage. Permitting the petitioner to raise all pleas at the appropriate stage, the petition is disposed.
Obliged.
Item 46.
46, my lord. Either, my lord. Questioning the proceeding on the ground of compromise, my lord. Affidavit is annexed.
46 and 47 both are case and counter case, my lord. Matter has already been settled between both the parties.
Put both matters together, 46, 47. Counsel for both parties state that they've compromised their disputes. They've entered into a compromise settling the disputes. That view of the matter, take the prayer clause in both, and all proceedings consequent thereto are very important.
Item 44 minutes. I was held up in the lift.
Tell, what is it? What is it?
44.
Tell us.
Lords, I have challenged the Lords complaint case. Lords, will kindly see the matter is also sub judice before the State Women's Commission. Lords, will kindly see the complaint petitioner. Lords, will kindly see page 17, para 12. No time, no date, Lords, no place, only Bhubaneswar, and no time. Lords, no specific.
Point out to all this, all you can point out to the trial courts. Permitting the petitioner to raise all pleas at the appropriate stage. Petition is disposed. Yes.
Item number 48.
None appeals dismissed.
49.
Same order.
Item number 50.
No instructions dismissed.
Item number 51.
None appeals dismissed.
Item 52.
May I please, your lordship? Here in this case, my lord, I have challenged the entire questioning of the entire proceeding, my lord. Since charge sheet submitted 376 2N 417 498A 494, my lord. They are both are major, my lord, as they are related. The present petitioner keep as the informant as wife, my lord. As per there is a settlement in the village, they stay together as a husband and wife.
When, my lord, thereafter, it is alleged that in the affair, he took away another girl, my lord. Thereafter, meeting was conducted. When he denied, my lord, the present affair has been lost. My lord, charge sheet submitted 490 to 376, my lord.
Raise all the pleas, sir. Permitting the petitioner to raise all pleas in the
Your lordship, target the case, my lord, within 2 months.
The petitioner to seek expeditious disposal of the.
Within 2 months, your lordship may direct.
No. Yes.
Item 53.
None appears dismissed.
Item 54.
May it please, your lordship. Already here, the initially, my lord, affair was launched. That is annexure 1, your lordship may say that.
Yes.
In the annexure 1, the affair, the informant states that I was the supervisor of him, and while being a supervisor, I stolen some properties of him. That was the allegation, and according to 79, Flat 06 was registered, and it was investigated. And ultimately, my lord, the final form was submitted by the annexure 2.
Yes.
The lordship may see that page 14, last paragraph.
Yes.
As the investigation of the case is completed and I submitted the FCR to SP Raigada seeking order of the case to return the case as a final report, false under section 379 506, received orders of Honorable SP Raigada by DR number so and so and dated with a direction to return the case as a affair false. Hence, I submitted final form as a affair false. The case was culminated then. Then she filed a complaint case, putting a completely new story. And that complaint case is annexure 3. And thereafter, the cognizance was taken against the petitioner. The petitioner protested there. Then there the magistrate held, as that matter is going to be settled within the parties, and for that reasons I filed here, Milord. And the notice was issued to opposite party number 2, but I did not back, Milord, till later. That is.
Permit you to take all pleas. Permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed.
May I pray, Milord, let it, I may take fresh notice to open number 2, because Milord, the matter is now going to be settled. Once it is found to be false.
You tell the trial court you've settled, sir. Get his statement recorded. All right.
Item 55.
With that liberty, you also
no need for liberty, sir. The petition is disposed. None appears. 55, none appears dismissed.
Item 56.
Permitted to be withdrawn. Permitted. Now, no instructions. Dismissed for no instructions.
And 57.
May I please? I am for the petitioner, my lord. My lord friend is for the opposite party, my lord. As for his instruction, my lord, the case has already been settled between the parties.
All right. Counsel for
yes, my lord. In the meantime, all the cases has been disposed of by the court.
Counsel for the respondent number 2. Opposite party number 2 confirms that all the disputes between the parties have been settled. In that view, the matter takes from the prayer clause and all proceedings consequent that we hereby quash.
Item 58.
May I please, before your lordship? My lord, here the petitioner challenges the parallel proceeding before the Law and JMFC Jajpur Road and JMFC Porjang, my lord, annexure 3, under section 12 of the PWDB Act, my lord. So that I pray for quashing of the second case filed under the 12 of the PWDB Act by annexure 3 may kindly be quashed, my lord.
Who's for the other side?
And 2 parallel proceeding. One is filed before the DB case, my lord, 152 of.
You are for the opposite party?
Yes, my lord.
You come to this side, sir.
Annexure 3, my lord, in criminal miscase number 9 of 2018 has been filed before the JMFC Porjang, my lord, in another court.
Under the same provision?
Same provision under section 12 of the PWDB Act, my lord. It was filed under misconception, my lord.
My lord. So which one should be quashed now? Counsel for the opposite party states that the second case instituted in the court of the JMFC Porjang
My lord.
Being criminal case number 9 of 2018
My lord.
was filed by mistake. That view of the matter, the said case and all proceedings consequent thereto are hereby quashed. The petition is
My lord, the first one may be disposed of within a stipulated period, my lord.
the remaining, as far as the other case is concerned, we open the parties to request the court for expeditious disposal. Right.
Item 59,
No instructions, your lordship.
No instructions dismissed.
item 60,
My lord. In this case, my lord, the initially complaint case was filed against the petitioner, and this is a dispute in between them, is civil dispute for violation of agreement. Kindly have a glance to the petition. In second paragraph, it has stated that agreement has been violated, and the violation of agreement is not a criminal proceeding. For that reason, I have filed this case for quashing of the FIR. And
Permitting the petitioner
my
to
lord,
raise all these the petition is disposed of the interim orders.
and in view of that, my lord, case may be quashed because it is a civil dispute. Arising
No,
of,
it's all
out of
the other side is not even here. Yes.
item 61,
420 is not made out against me, my
You
lord.
can point it out, sir, to the title.
In court below, I will raise with the.
Yes, yes. You can raise all the pleas. I've said that. Yes.
My lord.
item 61,
None appears dismissed.
62,
May I please, your lord?
Yes.
And here the petitioner is the principal
Hmm.
of a college. The data entry operator lodged the report
Hmm.
after 2 weeks of the incident, alleging that the principal insisted that the salary bills should be prepared by using the ID of the previous principal, which the data entry operator refused, and principal said, "You go out."
Hmm.
On that basis, FIR was lodged, and in the meantime, he has retired.
You can point it out, sir. Permitting the petitioner to raise all pleas at the appropriate stage. Petition is dismissed.
item 63,
Sir, I am appearing for OP number 2 in 62. My name may be recorded.
All right.
item 63,
None appears dismissed.
item 64,
None appears dismissed.
item number 65,
None appears dismissed.
item number 66,
May I please, lordship? Here, my lord, the petitioners challenge the impugned order under Annexure 3, my lord, taking cognizance of offence under section 498A, 313, 498A, 10934 of IPC, my lord. Admittedly, there is no marriage between the petitioner's sons and the opposite party number 2, man, as is reflected on the FIR under Annexure 1, my lord. There was a living relationship between the opposite party number 2 and the petitioner's son, my lord, for which there was demand of dowry, etc., by the petitioner's son, my lord, not by the so far as the petitioners are concerned, my lord. Even as
You can point out all that. Permitting the petitioners to point out all, to raise all pleas at the appropriate stage. All right.
item number 67,
None appears dismissed.
68,
None appears dismissed.
item 69,
The memo is taken on record. Dismissal is withdrawn.
68, I am for the opposite.
You have to come to the mic.
68, I am for the opposite party.
All right. You just say she appears to the opposite. All right.
item 70,
Please, your lordship. There is a defect, my lord. Extra copy not served.
That's all. Tell us what the matter is about.
The matter, my lord, kindly Annexure 4, page 30.
Hmm.
This is a, my lord, this court's order, my lord. The private party enclosed my government land and constructed in front of my residential house. Page 32 is the operating person, my lord.
Hmm.
We dispose the writ petition by observing that it is open for the petitioner to complain under section 133 CRPC, my lord.
Hmm.
Petitioner file before my lord, Lord SDJ, subdivisional magistrate, my lord, Annexure 3 is the order. Order is absolute, my lord. Operating person is page 29, my lord.
Page 28, my lord. 27 and 28, my lord, of my CRLs. In view of the above of the discussion, I am convinced that past party and both the parties have enclosed the suit plot number 3360, which causes public nuisance and is required to be removed through eviction. Hence, next page, my lord, 28, order dated 21/11/2000 followed. That is the observation, my lord. Thereafter, the opposite party challenged this order before the revisional court, my lord. That is the order.
There are civil disputes, sir. There are pending civil disputes between the parties.
No, my lord. Kindly see, my lord.
Consultation order has been passed.
Yes, sir.
Yes. The orders in consolidation.
No, my lord. Kindly see.
Page 27.
What is this? No.
Page
There are
27.
proceedings under the consolidation.
Page 17, my lord.
Page
Yes.
27.
Page 27.
Yes.
Sorry, man. Page 27, in view of the last time, my lord.
Yes.
In view of the above discussion, earlier I am convinced that the both parties have enclosed the board suit number 80, which causes public nuisance and it is required to be removed through eviction. Hence, order dated 21/11/9 followed by the order dated 3/13.
That's what has been set aside, sir. That order has been set aside in revision. That order has been set aside in revision against which you have come here.
I cannot see the revisional court's order, my lord.
I've already seen it. You have only now to see it. Yes.
Page 17, my lord.
Yes.
And last 5 line, my lord. Even if, as per the report of the Tahsildar, 6 line, my lord. Even if, as per the report of the Tahsildar, second party number 6 has enclosed any portion of plot number 3360, he may be liable for evict under the Orissa Prevention Land Encroachment Act 1972, my lord. Page 17, last, my lord.
Yes. You see, what is essentially a civil dispute resulting in the petitioner seeking removal of encroachment has been converted into criminal proceedings by invoking section 133 of the CRPC. Stop the impugn order of the Sessions Judge Puri dismissing criminal division case numbers 93 of 2015 and 95 of 2015. Notes this fact while setting aside the order dated 8/12/2015 passed by the subdivision magistrate Puri in CMC 448 of 2009. Paragraph. Having heard learned counsel for the petitioner and having perused the impugned orders, the court is satisfied that no error has been committed by the learned Sessions Judge Puri in dismissing the 2 revision petitions. No grounds have been made out for interference. The petition is dismissed.
Item 71.
None of it is dismissed.
Item 72.
May please, Your Lordship. And the offense under section 448, 294, 354, 506, 34 and read with the section 3 of SCST Act, my lord. The petitioner challenges the order under Annexure 3 at page 21, my lord.
Take all this, please, sir. Permitting the petitioner to raise all, please.
I am submitting 1 minute. But the order itself, my lord, it is out of jurisdiction. And the special act, it will be tried under the 3 SCST Act and before the special judge, my lord. Whereas the cognizance has been taken by the learned JMFC, my lord, which is out of jurisdiction. I have 2 decisions of this court.
Point that all out to the trial court, sir.
It is a clear case of question, madam. I have 2 decisions.
It's okay. You place those decisions with the trial.
Madam, I am placing.
Item 73.
Permitting the petitioner to raise all, please, at the appropriate stage. The petition is disposed.
Item 73.
None of it is dismissed.
Item 74.
Next to my lord. 74.
No. Why?
My lord, I am suffering from viral fever.
All right, we can tell you can say what the matter is about, sir. It's for quashing, correct?
passing of the annex of 4, right?
Order of
Passing of the annex of 4, my lord, right? Annex of page 19, my lord. Lots of grant time I will appear before honor in physical
376,
court.
sir. No question of interfering at this stage. It's 376. You say
No, my
permitting-
lord, my lord, no, my lord, your lordship had a moment. My lord, this is a FIR has been lodged by the complainant. After the investigation, police has submitted a final report. Then, then the complainant filed a one sitch and learned magistrate take a cognizance, my lord.
Yes,
So, my lord, your lordship had a query the additional affidavit which is filed by the petitioner, my lord. An additional affidavit. That is on record, my lord. The background
habitual
of the
litigant.
case is,
All
my
this you
lord,
can point. You can point this all out to the trial court, sir. Permitting the petitioner to raise all pleas at the appropriate stage. Petitioner is disposed of. The interim order is vacated. Yes.
Item 75.
No instructions.
No instructions dismissed.
Item 76.
I may be pleased, your lordship. This matter has already been settled between the parties.
Where is the affidavit?
I am objective, but no, 2 my lord, the matter has already
Counsel
been
for the opposite party number 2 confirms that the disputes have been settled between the parties. Annexure 2 is a copy of the compromise deed. That view of the matter take from the prayer clause, and all proceedings consequent thereto are hereby quashed.
Question.
Item note 77.
None appears dismissed.
78.
Same order.
Item 79.
None appears dismissed.
Item 80.
80, my lord, that matter has already been settled, my lord. That
I have appealed for the informant matter. I have also filed the affidavit, my lord.
All right. The affidavit and the informant has filed an affidavit stating that the matters have been settled. Counsel for respondent, opposite party number 2 also confirms this. That view of the matter take from the prayer clause. And all proceedings consequent thereto hereby quashed. All right.